Actually, I also filed in person also. This okay.
I am also coming from 1200 kilometer.
No, that is in
I also came from 1200 kilometer.
respondent. They are also say acts which are doing it illegal acts.
Give.
So
Whatever the mentioning, please give the mentioning list.
I am going to submit
Please give all the mentioning list to my court office.
The my need to file this shoulders circuit bench matter regarding SR experience.
Circuit bench is going on. No mentioning here. Circuit bench is going on in the Jalpaiguri. Mentioned before the Jalpaiguri.
No, lordship. No permitted to file before this court, lordship.
Circuit is there. How this court will file? Go and take the permission from the chief. If the circuit is there, this court is not having determination.
Authorized, lordship.
When the opening date?
I am your contractor. This contract was terminated. Move the arbitration. In the arbitration phase, that is before the joint measurement of completed and incompleted work, they will not interest the third party. Now, suddenly this particular tender has been floated in connection with your lordship the balance work. They have given the cost of estimation. They have your lordship also indicated in the tender this at the risk and cost of my kindly your lordship announce for you. Lordship, may I Monday, Wednesday kindly allow your Monday.
Monday कर दो, within 10 matters कर दो. Issue notice. हाँ हाँ
सर झूठो बोली
हाँ. So what is your prayer? What the authority will do that tenant and landlord dispute? Why? If the tenant is not vacated, how you so? Okay, give the mention. You mentioned that urgency.
One urgent matter.
Monday it is not possible. Okay, you give. I will see.
Lordship, may I be permitted to mention one matter for update?
Give all the mentioning list. Only I will take the unlisted motion by mentioning the matter. Otherwise, all the mentioning list be given to my court officer.
Tradition, Lordship.
All mentioning list be given to my court officer. Give the mentioning list. If there is urgency is mentioned, I will see to that. I will not hear every advocate now. You.
Despite the order passed by the Honorable Supreme Court, my lord. Despite the order, my lord, passed by the Honorable Supreme Court, my lord. The authority, my lord, is my lord, acting as the my lord, arbitrary, my lord. My lord, what happened, my lord? This is the order, my lord, passed by the Honorable.
What you want?
My lord, I want, my lord, immediate hearing of the matter. The name of the petitioner.
If you want an immediate hearing, you go to the Supreme Court. You are not understanding English. What is the urgency? Give in writing.
Lord,
Sir,
yes.
I want to apologize for the other day's outburst. Please forgive
Apologize not. If you want to come to the court in person, come with a decent.
me.
Threatening the court to making the complaint to the CJ, you go and make this complaint to anywhere. Not to threaten this court here.
Absolutely right, sir. I agree, sir. But see my mental state, sir. For 3.5 years, I haven't got my 7.5 crore. Sir, the police are supposed to protect the citizens of the country and against robbers, thieves, and extortionists. No, the people, the police.
My sincere apology.
My sincere apology, sir. Please forgive me. But just see, sir, this police department is misusing the judiciary. For 200, sir, they filed a writ petition and they want adjournment every time.
what is your matter?
Sir, my matter is I did a job for Kerala police. I got 7.5 crores. 7.5 crores was due. Now they didn't pay us as per the.
So why you came here? Kerala
I'm
police?
I'm telling you. So I took them to MSCV Council. MSCV Council, they called for arbitration. They quietly moved the High Court on 9th August 2024. 2024, sir, 9th August. Then that was Justice Sampath Sarkar. She moved it to November. Then went to the Court of Justice Amrita Sinha. After 9 hearings, sir, she gives this order, sir. Just see. And then, sir,
Then?
then, sir, it came to your court.
Hmm.
Now, sir, these people are taking adjournment after adjournment.
Hmm.
In one adjournment,
You are having the advocate.
Huh?
You have engaged the advocate.
yes, sir. So
No.
what I wanted to
If
do,
that's on the last occasion, I also told you, if you want to mention the matter in person, come with the advocate, let the advocate withdraw the power, then I will allow you. Your advocate's power is there.
I have withdrawn, sir. I've got the NOC.
Okay.
So all I'm requesting, sir,
Ah.
please, sir, please see my state. I'm bankrupt. I don't have money, sir. I've been thrown out of my house by the bank.
Hmm.
They've taken my property.
Hmm.
I'm living hand to mouth, sir. I just request your sympathy and empathy.
Tuesday, Rocco, within 5 minutes.
Sir, the matter was, sir,
Come on Tuesday.
the matter was listed on 13th May.
Come on Tuesday.
Tuesday को matter रहेगा.
Yes.
But one urgent matter, my lord,
Thank you, sir.
the petitioner name was last election, now name has
Thank
been deleted. Appeal has been filed, matter is pending. In the meantime, they have to go to the Hajj. They are not getting passport, my lord. There is some urgency, my lord. Let it be on Monday. I have served all the respondents.
Why not now? You all advocates are fixing your date of our own. So why you are coming here?
My lord will pass the date, my lord. I will not say anything, my lord. This is an urgent matter.
Fix उसको जो है Wednesday रखो within 10 minutes.
Your lordship, may I be allowed to mention extension of interim order? This my junior had mentioned thrice. It had come before your lordship left for the circuit bench. It had appeared, but the file was not there, so order could not be passed. This is a Union of India application against the fraud committed by
Of this court.
of this. Previous interim orders has been passed by the previous coordinate benches.
Till 18th. Till 18th order is there. Interim order is there.
Interim order has expired. We have filed a CAN application.
18th August order date 18th August. अच्छा 2025.
Your lordship.
इसको Tuesday. Interim extension of interim order can का साथ रख.
We had filed for certified copy. The file is lying in court, so the certified copy is unable to be handed over.
So what you want?
Your lordship, the file, this matter is going to appear in the August monthly list.
हाँ.
The file could be sent down for a week. Meantime, we'll take out the certified.
इसको फाइल भेज दो नीचे. ये फाइल को नीचे भेजो.
With the leave of your lordship, I was just mentioning this matter for a small correction.
Correction करो.
Inclusion,
Give all mentioning give.
my lord, inclusion in the list, my lord.
All mentioning give. Any unlisted motion?
Yes, my lord, is met.
I will not hear mentioning list. Give the mentioning list.
Unlisted
Only
motion.
I will take the yes.
Unlisted motion.
Along with item number 14.
Not in the court.
What is this? Can?
Yesterday, 3:30 notice for proceedings to be at 0.
So what you want? Today 14?
The tender number leave at 3 o'clock I mentioned and request your lordship.
No, it is fixed today.
Yes, Lord, it's item 14 of the original site list. 1/3 of the list. Original site list. Matter was being heard. Your lordship's order record, they will not throw us out without any. They came and said, we won't do anything, we take you to estate officer. Now, yesterday, 2:30 in the afternoon, I have completed submissions. Notice given for hearing today at 3 o'clock. But I made a chance. I'm enforcing the land policy. If not I go there, that's the end of my retribution.
But who will my
Then I
appellate?
come back at 1.
Okay.
The original side of.
Okay.
Lord, the private respondents of the society are trying to alienate the lands of the society.
I am telling mentioning list give to my court officer with the reason I will see to that.
My lord, inclusion in the list, my lord.
You
May I have your lordship kind?
yes, call the list. What is sitting here? Why you are not mentioning? Just you entered the courtroom. What is the urgency?
that the entire log which has been, they have seen the prospectus 6 above the log, the prospectus issued an order of auction of my entire timber lying in my sawmill.
Hmm.
The order of auction.
He might have been running the illegal sawmill.
I
Ah.
have the license, I have the purchase bill, everything which is with
Hmm.
me. I have obtained bill.
What is the order?
Yes, this is the order for auction of the.
When is the auction?
The date has not, they will do it any day. Can you see? Documented and undocumented, all. Right? At the bottom. They will auction the all, undocumented and documented. See, day before yesterday, though it is dated 30.
Monday रखो.
Issue notice.
Issue notice.
I am praying leave to move.
What is the urgency?
Appellate authority deleted, rejected the appeal.
SIR.
Yes, my lord, rejected the appeal. And my lord, my parents' name, brother, sister, all are enlisted voters. They cast their vote last election. My lord. Only my name was deleted in spite of all documents I provided before the appellate authority. My lord, any day next to me, lord. Any day.
I did mention. Yes, call the list. Call the list.
Terrific fire risk. Notice, terrific fire risk.
Yes.
Of the private.
Where is the return? Where is the return notes?
Terrific fire risk.
Where is the return notes?
Representation made to the fire authority, they are
Take the return notes.
they are in high position, they are not doing anything. Any untoward incident if happens, it will be a building dangerous effect,
My lord, I am seeking leave. There is a
Both parties have filed the return notes of argument. CAV. It abhi bhejo. Call the next.
May I try my luck tomorrow,
File my return.
I'm for the respondent back.
This was a case, my lord, of freezing of the bank account.
Yes.
He'll have to answer why it has been taken place because we've not been informed with anything. No proceeding started, and as per our knowledge, my lord, there is no order of any competent authority. But I'm covered, in fact, by 2 judgments passed by your lordship.
Who is for the bank?
I'm for the bank.
Yes, what is the report?
My lord, this account has been suspected as a mule account.
Huh?
Mule account.
What account?
Mule account.
New account.
Mule account. M-U-L-E. My lord, kindly appreciate this. My lord, kindly.
What is the category of new account?
I'm coming to that, my lord. Kindly see.
दादा देखो ना वो ले ना नहीं है तो दूसरे को बुलाइए ऑफिस से जॉइंट रजिस्ट्रार को बुला के लेके आओ नहीं होता तो ऑफिस से बुलाइए Yes, where is the new account? What is the definition of new account?
Kindly see page 60, clause 59.
Page?
Page 60, clause 59.
60.
60. My lord, may ask me the question that what authority the bank has if the account is even suspected mule?
60.
Then what authority? Yes,
16.
60, page 60, 60, clause 59.
This is the way to give the document to the court.
My lord.
This is the way to give the document to the court. अरे ले ना दे ना वो. This is the way.
No, my lord. I am extremely sorry, 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 my lord. It is my duty. I should have checked it. It is my duty. It is my fault.
In the advocate chamber, either senior is not having time or the juniors who are not having
I
time.
will not blame my junior.
Before appearing
It has
before
come
the
out
court.
from my desk. I will not blame any junior of mine. It has come out from my desk. It is my. It was my responsibility. My lord, kindly see.
Yes. Where is the new?
My lord. The instruction on opening of account and monitoring of transactions shall be strictly adhered to in order to minimize the operations of money mules which are used to launder the proceeds of fraud schemes, phishing, and identity theft by criminals who gain illegal access to deposit accounts by recruiting third parties which act as money mules. Banks shall undertake diligence measures and meticulous monitoring to identify accounts which are operated as money mules and take appropriate action, my lord. kindly notes this word, my lord, expression, including reporting of suspicious transactions to FIU, that means Financial Intelligence Unit of India. It is an organization of the central government. Further, it is established that an account opened and operated is that of mule, but no STR. STR means suspicious transaction report was filed by the concerned bank. It shall then be deemed that the bank has not complied with these directions. These directions of RBI has been passed under Section 35A of the Banking Regulations Act.
Just a minute. You have no knowledge that my staff is going on leave today? And you know the court is having a rush court. So why you're not giving the staffs? Huh? Because it is not possible to run the court with one ACO. Either he will call the list or we give the SIP.
We are that bank is supposed to monitor the transactions which has taken place in order to identify or in order to make the suspicion. It is a suspicion whether the account is a mule account or not. Kindly see page 38 clause 36.
38?
Page 36.
Of this report? Of this?
Of this one. Page 38 clause 36.
Yes.
Without prejudice to the generality of factors that call for close monitoring, following types of transactions shall necessarily be monitored. Large and complex transactions, including RTGS transactions and those with unusual pattern, inconsistent with the normal and expected activity of the customer, which have no apparent economic rationale or legitimate purpose. Transactions which exceed the threshold prescribed for specific categories of accounts. C, my lord, kindly, I am putting emphasis on this C, my lord. High account turnover inconsistent with the size of balance maintained. My lord, in this regard, may I place the statement of accounts of this customer?
What account is a saving or current?
The current account.
Yes.
My lord, kindly sees.
Just a minute. Just Sanjay Kumar Dalmi. Yes.
The account started operating, my lord, on 3rd March 2026. 5 lakh was credited.
3rd January.
3rd January 2026. 5 lakh was credited.
Correct.
Immediately 5 lakh went away.
Correct.
Thereafter, my lord, 1,98,52 credited. Immediately, my lord, on that, it happened on 8th. Amounts credited. Immediately, amount went away. A small balance is remaining every time. Thereafter, my lord, 50,000 credited, 1 lakh suppose went out. Thereafter, my lord, 1 lakh credited, 1 lakh went out. Immediately on 9th January, my lord, kindly sees.
Yes.
My lord, thereafter, my lord, at the end of this statement of accounts, my lord would see, my lord, kindly sees the last page of the statement of accounts, my lord. 10 lakh was credited from the account of Ninja Ferro of Chetla. Now, this company,
page,
my lord, kindly sees last page of this statement of accounts.
Which page?
Last page of this statement of accounts.
Page 9.
My lord, 10.
10. Yes.
My lord, kindly sees 10 lakh was credited. Ninja Ferro Chetla on 19th March 2026.
Ninja Ferro, yes.
My lord, this Ninja Ferro, they made a specific complaint against this company.
Who?
This Ninja Ferro.
To you?
Yes, my lord.
Against the petitioner?
Against the petition.
What is the complaint?
My lord. Well, it was made through mail, my lord. I'm coming to that, my lord. I'm sorry, my lord. My lord, my lord. My lord, kindly seize the last portion of this with regard to this 10 lakh reference, my lord.
Who is Ashish and Sharma? Who is Ashish Sharma?
Asin Sarba. Probably,
Ashish and Sharma.
probably that I have to know, my lord.
So where from you got that this is a ninja? Yes, what is that?
10 lakh, my lord.
Reference to the customer company, erroneous transaction has been made by the customer rupees 10 lakh from the account. Four three zero.
My lord, in this within the statement of accounts also, my lord. My lord.
Kindly come that letter you are having.
My lord.
You have given to me. Come to the last 4 lines.
My lord.
With reference to the customer's complaint, erroneous transaction has been made by the customers of rupees 10 lakhs from account number 444689. Whose account is this?
Account number 4, my lord.
4664893234494.
Is not my customer's account. This is not the customer's account.
Ninja Ferro Technical to the account number so and so so and so.
My lord.
Correct. And that's why I'm asking who has given this complaint?
This complaint was made by this Ninja Ferro, this
No,
alloy.
it has been given by one Ashish and Sharma.
But it was what I have my instruction is this complaint was lodged in the UNO portal. UNO portal. UNO portal is the portal of the SBI. Lodged by the Ninja Ferro.
No, kindly see the mail. It is with you.
Yes, my lord.
First top from
my lord
Ashish and Sharma. Correct?
My lord.
On behalf of support business. Ashish and Sharma in BTech SBI. So it is the man from the SBI.
SBI.
Correct. To whom? SBI Chetla.
Chetla.
Copy to then your bank authority.
Yes, my lord.
So where is the complaint?
This was, my lord, my instruction is this Ninja Ferro. They have lodged this complaint to the YONO. YONO is the app of SBI. They have lodged, and thereafter from there deriving that, coming to know that complaint, this Assistant Sharma or the man of the bank personnel has forwarded to the concerned branch.
Correct.
Concerned branch.
Correct.
This is a mail between the two banks.
When this account was freeze?
19th March 2020.
On the same day.
On the same date.
So only because of this 10 lakh.
Not only 10 lakh. Also, my lord, that I have pointed out for this mule account transaction, my lord, also kindly sees this. There is another company beside this one, my lord, kindly sees. So this, my lord, I have there is a company called, my lord, Dragger Comotra. I'm pointing out that. My lord, kindly sees page 8 of the statement of accounts. On 10th March 2026, my lord, transaction from this
1 lakh rupees.
1 lakh rupees.
Yes.
On the same date, 1 lakh rupees. My lord, this dagger Komotra has already been declared as a mule.
Huh?
This account has already been declared as a mule.
Whose?
This dagger Komotra
Ah.
by the competent authority, my lord. Now, my lord, these accounts, what happened, my lord? These
For
accounts are
declaring
sometimes-
the account mule, what is the procedure?
procedure is we are supposed to report it to FIU.
Correct.
FIU is supposed to take the decision.
Correct.
Now we have suspicion with regard to the account,
Correct.
and we are required to take appropriate steps
Correct.
pertaining to the account.
Correct. These are 13 January, 13 March,
19th March, my lord.
19th March.
Yes,
Where is
ma'am.
the complaint given by you?
My lord.
FUI. Where is the proceeding initiated by your bank to declare the account mule?
My lord, we have.
I am asking
Yes,
one
my lord.
question, one by one you give the answer.
Yes, my lord.
Correct.
My lord.
Not to go air.
No, I will not. I will not.
Directly putting a question on 19th, you have, as per your submission from 1st of March 2026, you find that transaction is coming and immediately is withdrawing. And on 19th of March, 10 lakh has come. Immediately, one report has come. You have made the account freeze because of you declaring as a mule. So I am telling that where is the action taken by you for making the account of the petitioner as mule?
My lord, we cannot declare the account mule. That has
What
to
is
be.
the action taken by you?
My lord, my instruction is this: on 19th March 2026, we have reported to the branch.
And show me, you have brought all the documents. Show me what to whom you have given the report.
To the dedicated branch of the.
Show me.
That document, my lord, I am not having right now with me.
The petitioner has filed the present writ application.
I may file
on the
affidavit.
ground that the bank has illegally freezed the account of the petitioner, due to which the petitioner is not in position to operate the bank account, though the account of the petitioner is a current account. Learned counsel for the bank submits that the bank has found that since the 3rd January 2026 till 19th of March 2026, there was several transactions has been made by the petitioner. On 19th of March 2026, 10 lakh rupees was credited in the account of the petitioner. In the meantime, a complaint has been lodged by one Ninja Ferrotech Private Limited to the support, and support has informed the same to the bank. Accordingly, the bank has freezed the account. The counsel for the petition submits that he has got the instruction that the bank has declared the account of the petitioner as mule.
No, my lord, that is
mule. Accordingly, the petitioner is directed to submit. Accordingly, the bank is directed. Yes.
We have suspected it's a mule. We have reported to the concerned
Suspected
branch.
in you've done all the things.
We have reported to the concerned branch of the concerned branch, and
the
they are supposed
respondent
to
bank
declare.
that submit that the bank suspected the account of the petitioner as mule, and they have taken appropriate step for declaring the account of the petitioner as mule. Accordingly, the respondent bank is directed to file the detailed report. By disclosing all the documents within a period of 10 days from date. After serving the copy to the learned counsel for the petitioner is liberty to take exception to the report, if any, within a week thereafter. Full stop. List the matter on 5th of August 2026 under the same heading within 10 matters.
Lord, may I, my lord, seek your lordship's indulgence for an interim order? But because my business at the moment has.
But there is allegation. You are coming 7 lakh, you are withdrawing 7 lakh. Coming 1 lakh, you are withdrawing 1 lakh.
May I just say one sentence? And
Let they come. Let
only
the
one
report come.
sentence, my lord. I'll not disturb your lordship any further. But I'm covered by 2 judgments of your lordship.
Let the come.
Sir, complaint will not do, my lord. There has to be an order passed against.
That's what the court say. Let they file the report.
Very well. We'll come back.
Let they file the report
We'll
before opportunity, whether the bank can do. Let they file the report.
We'll consider that and come back. I'm grateful.
Yes, next.
My lord, this is that passport matter, my lord.
Yes.
The question, my lord, was firstly, my lord, I am led by Mr. Amit Ranjan Pruthi. He's before the division bench. I'll start the matter, my lord. He shall join me later. My lord.
What is the matter?
My lord, this is that matter, my lord. This is regarding the extension of the visa. A penalty was charged of 2 lakh rupees,
Yes.
which upon the last occasion my learned senior communicated before the court
Hmm.
that it is regarding the registration, my lord. Now, my lord, I shall take you, my lord, to the page number 8
Hmm.
of
Page
my
number?
8
8 of?
of my supplementary affidavit, my lord. Kindly sees when they have notified me regarding the registration.
8 of supplementary affidavit.
Page 8 of supplementary affidavit, my lord.
Correct.
Kindly sees the date service rendered on.
Hmm.
Point number 9. The date is on 26th November 2025.
Hmm.
My visa expired, my lord, on 8th August 2025. My lord.
Correct.
Correct. My lord, they have notified me regarding the registration on 26th/11. Now, my lord, if I come to the one second. If my lord sees the language of their own statute,
Hmm.
kindly, my lord, sees the section 6 of Immigration and Foreigners Act.
Yes.
May I, my lord?
Yes.
Registration of foreigners, it says, my lord, the foreigners on arrival.
Section 6 of
6 of the Immigration and Foreigners Act.
Act.
Yes, ma'am.
Yes.
Has, my lord, section 6, registration of foreigners, my lord, their statute itself says foreigners on arrival in India
Hmm.
shall be required to register with the registration officer concerned,
Hmm.
subject to such conditions and in such manner as may be prescribed.
Correct.
So, my lord, my client was under the impression that the registration has to be conducted on arrival in India.
Correct.
Accordingly, she registered, and subsequent to that, she has never left India.
Hmm.
While staying in India, when the visa expired, she applied for the extension.
Correct.
Now, my lord, this is the general visa information, my lord. The copy that. My lord, internal page number 5.
Yes.
Internal page number 5, my lord, below section 26, which deals with the registration of medical visas. Now, my client, my lord, as I have intimated the court earlier, is a cancer patient. She's here on a medical visa.
Hmm.
Subsection 2, my lord, says if the medical/medical attendant visa is valid for a period of 180 days or less,
Hmm.
no registration will be required.
Hmm.
Now, my lord, kindly sees when the visa was granted to me.
Hmm.
The visa initially was granted to me, my lord, on 20 October 2024. 20 October 2024. That was valid till 8th August 2025. That's a span of, my lord, almost 292 days.
Where is when
My
the
lord,
first
I shall
when
show
the
it.
first visa was granted to you?
When
When you entered India?
I entered India, my lord. Previously, I've entered India on student visa.
Lastly.
Lastly, I entered India, my lord, on October 2024 when my visa was granted to me.
October 2024.
2024, my lord. My lord, this is the stay visa that was granted to me. It is notified here, my lord, 20 October 2024 to 8th August 2025. It is on the top, my lord. The period, my lord, between October 2024 to 8th August 2025 is 292 days.
Correct.
My lord, if for 292 days I have been granted visa, my lord, then subsequently that is going against their own delegation that they have produced before, my lord, for registration of medical visa that I've intimated, my lord, in section 26 of the general visa information. They are saying that no registration will be required for 180 days or less. They granted me a visa longer than that. However,
Where is the for your medical visa?
my
Where you found that it is a
visa, my lord, I'm led by Mr. Amit Ranjan.
I am apologize for my last occasion. It was, my lord, the question was put to me whether I have an extension with regard to my FRRO registration or not.
Yes.
Then, your lordship, I showed your lordship a page 8 of my supplementary affidavit, which my learned junior just now showed to your lordship. My specific point is that I had a registration.
Because my lord, kindly take page 8, the slab, the table. Kindly, my lord, kindly take the second column from bottom. This is the last registration I had. According to them, my last registration provided up to 19/10/2024.
Correct.
Then my lord, page 7, that is the visa.
Yes.
Kindly take page 7. This is
Yes.
the last visa.
Yes.
My lord, kindly take the serial number 1.
Yes.
It says that serial number.
Hmm.
My lord, subject to correction, my learned senior can confirm it whether I am right or wrong. That service number is my extension number with regard to my registration.
Hmm. Yes.
Then my lord, kindly take the column number 2, RCF number and UCF number. That is my registration number.
Hmm.
Then my lord, entire things was given,
Hmm.
and serial number 9 is the type of visa which I am getting right now before 8 August 2025.
Hmm.
Now my lord, over there, then page, my lord, kindly take.
Now, can you see also serial number 11?
I'm coming.
Yes.
Serial number 11 says that RPRC and visa extended till 8/8/2025.
Correct.
So according to these documents, that my visa extended up to 8 August.
But student visa.
No, medical visa.
Kindly see.
Medical visa.
So, my lord, subsequently it's written daughter is
Observation. Visa extended till 8/8/2025. Daughter on student visa, employment, business, study not
and
permitted.
my lord, nature of visa, my lord will get it page column number 9.
Hmm.
Visa type.
Yes.
Visa type. My lord, column number 9. It says entry visa.
That is earlier one. Visa type and valid for. This is the medical visa.
That is the last one.
Correct.
Then subsequently I extension for medical visa because my lord, I am suffering cancer and getting treatment over here.
Where is the extension? This is August 2025.
That is the first application, my lord. In respect of my first application is on September 2025.
Correct.
Now, my lord, kindly see the page 8 again, my lord. I request your lordship to take page. Kindly see the communication date they made to me. In the bottom it says 26/11/2025.
Yes.
So, my lord, if at all the charging, whatever they are charging for the registration fees, if at all they could have charged me, they could have intimated me, my lord, after my first application on September, my lord, 3rd. That is my first application. But they, my lord, charged me for that registration in the month of November, after 2 months. So which caused, my lord, right now, that is why they are saying 180 to 1 year I come down. Because otherwise I would have been come down, my lord, within 90 to 181 parameters. So that, my lord, the fine amount could have been less. Now, my lord, second point is that, my lord, kindly take the, my lord, the manual which.
So what is the submission here?
My submission is that, my lord, I had a registration unless they.
So your contention is that your registration is continued. You are on medical visa. So question of further registration is not required.
Registration fee should not be imposed on me.
Okay.
So far as overstaying, my lord, I am not disputing. So far as my 1 lakh overstay. Now, my lord, in manual they have stated, and my lord, your lordship take the note of the fact that the registration of my extension visa granted 20/10/2024 to, my lord, 8 August 2025, which is more than 10 months.
Correct.
Now, my lord, kindly take the manual according to them.
Yes.
My lord, column my lord, internal page 4, the medical visa.
Yes.
So, my lord, what is the point is troubling me is that everywhere stated, my lord, on arrival in India. My lord, it's medical visa. My lord, kindly then take, my lord, page 26 is the registration with regard to FRR.
Yes.
Page 5, point number 26. My lord, first they have stated that foreign national other than Pakistan national holding medical visa / medical attendance visa for a period of exceeding 180 days will be required to get themselves registered with FRR, which I did already. Concerned within 14 days on my arrival of it.
Correct.
Then said that if medical attendance visa is valid for a period of 180 days, my lord, it can't be because they last time extended me for a period of 10 months. Day or less, no registration would be required. So, my lord, according to my submission before this court, that the registration.
No, if the medical attendant visa is valid for a period of 180 days or less.
My lord, my last extension given more than 1.
Let first you interpret this, then we'll come to your visa. if medical or medical attendant visa is valid for 180 days or less, no registration would be required.
Matlab,
Correct.
my point over here is two. If they granted me till 180 days,
Hmm.
then perhaps I would fall under this category.
Correct.
If they granted me extension for my lord less than 6 months,
Hmm.
then also I would come under that.
Hmm.
But here my specific case is that my last extension was granted more than 180 days.
Correct. More than 180 days, no problem. Okay. If we go by your submission, it is August 2025. What about the after August
Matlab,
2025?
my first application on September 3rd,
What?
my extension of visa as well as that registration.
So that is this one.
That is, my lord, they communicated me on 26/11/2025 after period of 2 months, if at all I accepted. Then they closed my visa.
Where is your application?
My lord, I have annexed in my supplementary affidavit, page 9. Because in the report, my lord, they have substantiated.
Where is your application?
My lord, page 9,
Uh-huh.
on the, my lord, right-hand side top.
3rd September.
3rd September is my first application.
Correct.
My lord, then kindly take their
3rd
report.
September 2025.
Now,
That is after
five,
the
yes, yes.
after the visa is over.
Over.
Correct.
1 month. Now, my lord, kindly take their report. Their report is handed over to you. Because if it's their document, it's better for me to rely on that.
Hmm.
Point number 4, my lord.
Yes.
He further applies for visa extension on 3rd September 2020.
Correct.
However, her previous visa had expired on 12th.
Correct.
So a penal charge of 10,000.
Correct.
So at the time of my lord, my first application, which is unfortunately got closed, they did not charge me for registration.
Correct.
They only charged me for overstay.
Correct.
10,000. Now, my lord, but the application got, my lord, closed. Though, my lord, I mailed them why I hold my fine. The mail I have annexed in the report. Then, my lord, they said that para number 6, she again applied for visa extension on 12/4/2026. Now they are asking me that I have to pay the registration charge. If today, my lord, I have asked to pay registration charge, then my first application, they also could have charged me for registration.
You read the para 5?
The para 5 said payment request was sent to her 9 times,
Hmm.
but several times it was auto pulled due to non-response from the applicant.
Correct.
So she was given ample opportunity to pay the penalty, but the applicant did not honor the payment request, hence her application was finally closed.
Hmm.
This office gave the applicant ample opportunity to comply with penalty rules
Hmm.
and regulations.
Hmm.
Her application was cancelled on, well, kindly take the date. My first application is on September 3rd, 2025.
Correct.
After almost, my lord.
Correct. They are telling that they have given 9 times they have given the opportunity, but you're not
my
given
lord, I
response.
Because what has happened?
You show me you are corresponding within September 2025 and 27th of March 2026.
My lord, in read petition, my lord, I have mailed them. I have
Show me.
that why I hold that payment. My lord, page number, my lord, 70. According to my lord, what I mailed them is that at the same time, my lord, I applied for extension of my daughter visa as well.
Hmm.
It was informed by the FRRO is that once my daughter extension would be there, then further processing for in respect of my application could be better for me. So they advised us to hold that payment. So
what is 72? Where is 72?
my lord, that is page 72 in my repetition.
Ah.
My lord, this is the mail. Kindly take the date, my lord, December 12, 2025.
Correct.
My lord, I made them specifically.
What you request?
What number line? My lord, kindly take the 13th line. And we have, it says that have these diagnosed for last 16 months. Our visa has expired on. My lord has got it.
Which where?
My lord, sixth line from the top. 13th line from the top. My lord, the line starts with our visa has been expired on 8/8/2025. Then we have applied for extension on 3rd September, me and my daughter. Now, my lord, we were a bit delay because I am explaining you that I am a severe cancer patient now. because I am found a bone matrosis cancer last stage patient. So I have restriction on my kind of movement. I have annexed the medical documents as well. Now, my lord, so and so, so and so, so and so. I was medical part, he said. So I was not in a position to apply for visa on extension earlier than that. But there again, I was informed to visit FRR office for 4th time. I have visited by wheelchair, but they can't give any solution because they have asked for more documents. I have uploaded that frequently on my application, but they are saying they can't see that. But my point is that if they can't see my documents for the reason, I cannot be the sufferer because I have all nail and details on my application. Then again, they have instructed me to take an exit, which is not possible as my daughter is in running student here now. And I am continuing all my treatment procedure here for last 1.5 years and more than that. Then again, I was instructed to visit FRR office with documents. I went and then they instruct me to reapply individually for visa extension without seeing my document. Then, my lord, the second application is on 12th March 2026.
Yes.
They told me to apply my daughter's first. She gets once, then I have to apply. I have followed those accordingly again with my full cooperation of with my full of cooperation in this severe health condition. Caused I have to wear
Yes.
oxygen.
Then what has happened
My
after
lord,
this?
then the second application I have referred on 12th April 2026. Now they are asking me that I have to pay penalty for two. One is for my overstaying and another is for my non-registration.
12th of April.
12th of April. My lord, I have annexed in my supplementary affidavit at page 12. Because according to them, 27th March 2026, that earlier one
Yes.
got closed. So immediately I apply. So my lord, admittedly, if there is a at all delay is from my lord 8th March, 8th August 2025 to my lord first application of 3rd September 2025.
Correct.
I can't deny that.
Correct.
That is admitted.
Correct.
But my lord, whether they will consider my that medical issue or not, that is up to them because they are prerogative of that entire issue. But so far as application subsequently is entirely, my lord, due to fault on them, non-communicated me that I need to get a registration because I had a registration till 8/5/2025 admitted in a document.
So what has happened to the after the 3rd September?
Now they are charging 4 lakhs.
No.
Not 2
What has happened after 3rd September?
That application got closed as I failed to pay that 10,000.
Where it is? Close.
From their report, it is evident.
They did not communicate that to me, that it was closed.
Okay. Okay.
Para number 5. My
Yes. Yes.
And my lord, my specific.
No, that is cancelled on applicant was cancelled on
27 March.
March.
My second application, is on my lord 12th
April.
12th April.
You are given second. Okay. Okay. Yes.
Now, my lord, my point is that when I applied for first time, they only charged me for overstay. There is no requirement for registration. Now, my lord, as I put a question that how can you charge me 2 lakhs, they come up with a plea that I need to get registered myself, and for that reason I have to pay another one.
Yes.
That is my submission before this court.
Now, my lord, kindly down, my lord, page 7 of the supplementary affidavit. Page 7.
Yes.
Now, page 7, my lord, it says, my lord, RP, that is, my lord, residential permit, RC, that is, my lord, registration certificate, visa extended from 20th of October 2024.
Where from you are reading? Page 7.
Page 7.
Yes.
Page 7, my lord, just service granted, that is stay visa. As you got it, just first, second, third, fourth line.
Service granted, stay visa.
Stay visa. Next line.
Yes.
RP, that is, my lord, residential permit. RC, that is, my lord, registration certificate. Extended from 20th of October 2024
Correct.
to 8/8/2025.
25.
Next. Kindly turn to my lord 11. Observation. Observation says that is residential permit and registration certificate and visa. Registration certificate and residential permit and visa extended till 8/8/2025.
Correct.
Now, my lord, kindly see, my lord, last there is some instructions provided. Third one, last from bottom, third one.
Yes.
RP, RC shall be renewed at least 1 month before the expiry of the present RP and RC. Can line friend may say all these things now? These are then provided in the while granting extension. Now he is saying he had not been informed.
This is there in their document. It has to be extended prior to the expiry of 1 month.
Okay, so it is, they could have been applied in the month
Yes,
of July itself.
Yes,
So they have applied on September.
September.
They applied on September.
They applied on September. Thereafter, 9 times reminder were given. They did not respond to
9 time reminder is something different kind. Then you come to page 72.
72.
72.
72 is their mail.
Yes, 72 is the December.
December 12,
Yes.
2025.
Correct.
Now, page 7 is clear. Page 7
is okay.
Page 7 is absolutely clear. Now, your lordship knows, this act came into force on and from 1st September 2025. Now, the rule 12 clearly provides that each and every time he has to ask for extension, apply for new registration. Have a look, rule 12 and rule 13. Yesterday, your lordship also pointed out rule 13.
Whereas rule 13 is not applicable on me, rule 12 will be applicable, provided clause.
Now, rule 12, your lordship kindly see, rule 12, sub-rule 1, then proviso. Provided that in case of a foreigner who enters India on a visa and he intends to stay in India, he shall register before the expiry of the period permitted for rule 12.
Rule 12?
Page. Rule 12, 1, first proviso.
That portion,
your lordship is looking this commercial book.
19, page number 19.
Your lordship is looking this commercial book. Commercial book. Yes. Page 19.
Yes.
Rule 12.
The bottom portion.
1, rule 12, 1, A, B, then first proviso. It says, provided that in case of a foreigner who enters India other than on a visa, and if he intends to stay in India, he shall register before the expiry of the period permitted for stay on arrival. Now, kindly turn bottom, second one, second proviso.
Yes.
Provided also, in case of a foreigner who enters into India on a visa valid for a stay in India for a period of 180 days or less, and wishes to stay in India beyond a period of 180 days, he shall register within 14 days after the expiry of 180 days on his arrival in India. Provided also,
first proviso provide that in case the foreigners who entered India
Yes.
other than the visa,
yes,
on a visa, and if he intends to stay in India, he shall register before expiry of period permitted in the stay arrival.
Yeah,
Correct.
next.
Then, where the resident citizen of India becomes a foreigner, that is not here.
That is not applicable. Now, next provided also. Provide
In case the foreigners who entered
in
India
case of foreigner,
on a visa valid for stay in India for a period of 180 days
or less, and wishes to stay in India
beyond period of 180 days,
he shall register within
shall
14
register
days
within
after
14
the expiry of 180 days of his arrival in India. So registration is must. It is not once I arrived in India that one registration will continue. This cannot be the.
But it is it's a medical visa.
Yes.
Then what the rules say? This says, what is this? Guidelines?
Well, so far as this one is concerned, I don't know whether it was visa manual. Whether it was after the.
Yeah, when that's why
That's
when
it,
it was.
I was when it was. Must be prior to first.
No, it's not prior to.
I have to take
Subject to
instruction.
correction, my lord. Why I am saying, my lord, what my learned senior just now read, it also contrary with their doc. My lord, I am.
No, this rules with this. What is this?
2025 September.
How? Where it is notified?
This is nothing is appearing from the document.
Which date? It is published.
Then, my lord, I need to bring the entire document.
So you persons are bringing something before the court. You have to bring all these things.
I thought, my lord, that it is a manual, my lord. It is a
Manual, I don't know. That's why if it is then the rule has to, which will this manually prevail or the rules will prevail. So this rule has come into September 2005. 1st September 2005.
My lord, what my learned senior just now read, I am again reading, my lord, provided that in case of a foreigner who entered into India on a visa valid for a stay in India for a period of 180 days or less. My lord, I am pausing for a moment. My extension was granted for 10 months. Can you do that? Now they are asking that if I at all stay 180 days or less, then I have to
No,
register.
now here the only question is not that question. Here the question is August 2025, 8th August 2025, visa is there. Correct. In that visa, there is a condition. In that visa, there is a condition.
Yes, before 1 month, I need
Before
to
1 month, you have to apply for it. You have not applied for that.
admit.
Correct.
My lord,
So what would be
my
effect
lord,
on
then,
that?
my lord, whatever instruction they are passing at page 7, contrary to their.
So that time the act of not there.
Not contrary. See, the
But what
court
I'm
has to see. The authority might have been left. But now before the court, you are giving your point, the respondent is giving the point, the court has to
But
see.
what I am saying-
Once you accepted the extended visa till August, 8th August 2025
It is
in,
documents, I can
in-
dispute.
Huh?
It is in the documents, I can't
it is
dispute.
the India.
It is in
So
the
that's why you give the reply. So here categorically RP and RC.
Yes.
Correct.
Yes.
Shall be renewed at least 1 month before. So 1 month before means so you could have been applied before 6th or 7th July of 2025. Then you have applied on September 2025. 3rd of September 2025. That is after 1 month. After 1 month. So if you are not applied for and the visa after the 2025 the registration is not there, what would be effect?
Their rule says after 180 days I can apply. Because my lord, second link of that provided clause is saying that we say.
That is with regard to the first. See, that is that rule. If you came to India, visa granted 180 days, you can apply.
My lord, then my lord, subject.
Here your case is different. You are already in India. Extension has already been granted for more than for about 11 months. 2024 to August, 11 months. 11 months and 11, when it was granted, it was informed to you that you have to apply before 1 month. If you are not applied before the 1 month, so what would be the effect?
My lord, then my lord, subject to
What would be
correction,
the effect?
whatever they are charging me for the first time is contrary to their stand.
Why?
Because my lord, kindly take their report.
Yes.
Again, my lord, I am apologize. Multiple time I am requesting my lordship to take their report. Report for them. My lord, point number 4. My lord. She further applied for extended visa on 3rd September.
Correct. Correct.
However, her previous visa had expired on Eto.
Correct.
So a penal charge was 10,000.
Correct.
How can that be? Because penal charge is only for overstaying.
Correct.
At that point of time, they didn't.
So
charge me for
if
registration.
suppose in the report they have not mentioned with regard to that,
With regard to charging.
so
me
can
for-
you take the benefit of that?
Now,
If
whether, my
okay,
lord,
in the
it is
report they have not mentioned with regard to this. Now that's I'm telling. Now at the time of argument, the authorities came to know this is the position. Now they are pointing out this. That's why I'm asking. That's why I'm asking if this is the condition in your visa and you accepted that visa. If you not fulfill this condition by applying before a month and your visa is expired on on 9th of August 2025. So what would be effect from 9th August till today? Tell me.
As I applied for 3rd September 2025,
Ah.
they could have charged me for, even if I accepted their argument that prior to 1 month I have to apply.
Correct.
That means, my lord, for 1 month they could have charged me for registration fee. If at all I am not
So
accepting.
what is the rate of the 1 month?
My lord, rate of the
10,000.
1 month is given
10,000.
10,000. So, my lord, if at all my application got closed on March 27.
27.
So my first mail to them is on 12th September. So it's not that case, my lord, that I am staying without doing anything. I multiple time wrote, visited to their office, wrote a mail. And then, my lord, if at all I take that point, then I should be charged for, my lord, 12th April 2026, where I made a second application.
Correct.
Thereafter, the time taken by them due to process. So for that reason, my lord, should I be penalized for that?
So for now you come to the report this
Submitted by respondent.
yeah this the foreigner staying in India without the valid passport or travel document, that is one it report notification.
Yes, the page 11.
Page 11.
Non-registration by foreigners violating provision of section 6.
Section 6, correct.
Says that
Now
up to 30 days, 10,000.
180, yes. In case the foreigners other than this 1 day up to 30 days, 10,000. So you have not applied with
within 1 month.
8th August till 8th August you are having.
Yes.
So 8th August till 3rd September.
Yes.
1 month. 10,000. 10,000.
Then, my lord,
One thing, may I submit one thing? kindly text me on page 7 once.
Yes.
Page 7, my lord, speaks about, my lord, he has to apply within 30 days. Now, my lord, it is dated, my lord, 8th of October 2024. This document was generated on 8th of October 2024. So far as this act is concerned and rules thereafter, right, it came into force on and from 1st September 2025. So, my lord, this is not applicable so far as, my lord, this part is concerned. Now, my lord, so far as this is clear, he had the knowledge, my lord, he has to apply it within.
Correct.
No, I leave it. No, so far I leave it.
Had the knowledge, he has not applied, so that's why the period is given.
Yes.
The
Well, so-
notification, when the, what is the date of the notification?
Notification is
September
1st September 2025.
2025.
Yes, yes.
Correct.
1st
So
September.
this effect, this notice is coming to force.
Yes, yes.
If it is coming to force, so August, though he had not applied within 1 month.
Yes.
So that is up to you whether it is to be extended or the fine is to be imposed. So, but rightly or wrongly, 8th August 2025, the visa is there. The permit registration is there.
Registration is there up to 8th
Registration
August.
is-
Yes.
So he has only applied 3rd of
Third,
September. So 1 month.
1 month. Now, my lord, so far as third, thereafter, my lord, certain things are
Third-
there. Paragraph 5 is also, my lord, there. Now, my lord, again applied.
And
Now, what-
that's why again applied on
12th.
12th of
It can be, my lord, up to 12th.
12th of April.
Yes, 12th,
12th
of
April.
Yes.
2020.
Today, we are in,
Six.
yes, we are in,
2026.
we are in, my lord, July.
No, but problem is that
I have
this
informed-
3rd September 2020, 2025, which they
Yes.
have applied,
Yes.
you have stated that in paragraph 5, 9
Cancel.
times you have given. But the contrary document they have enclosed in this in the page 17 of the retweet is
72 in the report.
72.
So, my lord, in that case, my lord, I have to file, my lord, further reply. My lord, kindly have a look, my lord, page 5, paragraph 5. That application was cancelled on 27th of March.
March. That's why
2026.
27th March.
March. Now, my lord, again applied. See, again, once he applied for, my lord, further visa,
But
earlier goes.
But we have to see whether the petitioner was cautious for applying that. You rejected or not? You rejected. What is the ground of rejection? Paragraph 9, paragraph 5.
Paragraph
9
5.
times.
9 times.
So then the contrary, the kindly see, or you take the instruction, kindly
Yes.
come to the page
Page
72.
72.
Page 72, whether this is what steps has been taken by you.
My lord, 9 times reminder was
9
given.
times reminder, where is the reminder?
Then in that case, my lord, I have to file a short
You
report.
do one thing,
Yes.
come tomorrow, day after tomorrow with the short reply.
Yes. The day after tomorrow. Monday. Can you give it
Monday,
Right.
come with the short reply because you are telling them the 9 times.
9 times.
There is a contrary document of
Yes,
72.
72.
72.
Can allow to provide the messages which I received, because my lord, messages also showed that after 26/11, according to them, when they asked me for it.
That is the problem with all of you. When you are filing the writ application, hurry, burry, 2-page, 2 annexes, filing the writ application. When the court started inquiring, supplementary, then supplementary, supplementary, then supplementary. Like the respondents also, they filing the report, then the court, then again the report.
Initially, what we thought that the amount charging is for overstay.
Thinking, see,
Subsequently,
once you're drafting the writ petition, you think what would be the question from the court and what would be the act.
we were
Only what the document, 2 document, yes, I will get the order, that cannot be. This is a 4th time, a small matter.
My lord, I understand. My
And
lord,
1 hour.
my lord,
My lord,
it's my-
initial cases, my lord, 4 lakhs was
You
excessive.
do one thing, how soon you will file? Monday. Monday you give the copy to him. Monday give the copy to him. You take exception, I am fixing on Wednesday. Because you are telling that you are having the SMS,
Brother,
whatever.
even
The problem is, my lord,
When you are leaving.
Tuesday, Wednesday, and Thursday, my lord, I will not be here. So, my lord, it can be on Friday or, my lord,
Friday, what is the Friday? Heard the learned counsel for the parties at length, full stuff. And learned counsel for the passport authorities press for time to file report, supplementary report disclosing the request made to the petitioner for 9 times as appearing in para 5 of the report dated 29th of June 2026. Let the report be filed by Monday after serving the copy to learned counsel for the petitioner. Petitioner is liberty to take exception to the said report by Wednesday. This is the matter on Friday within 5 matters under the same heading.
development.
Because it will affect other cases.
Yes,
That's
yes,
why it
will-
has to be dealt
has
with
to be
seriously.
set up.
I have got the messages to my.
Yes, yes.
Yes.
Sorry.
उसको आज है ना उसको बोलो अफर्म करके नोटिस सर्व कर दो, उस समय फाइल कर दो जब ये 3 बजे है ना, 114 नंबर में है। उसको बोलो उस समय मेंशन करो, फिर हम देखेंगे क्या होता है, क्योंकि ड्यू दे दो।
Grateful. And I am apologizing.
Yes, next.
Lordship, in this matter, I am appearing on behalf of the petitioner. The petitioner herein has sought for their.
What is the case?
Lordship, this is the case for
Where is
treatment
the
relating
affidavit of
to
service?
affidavit of service.
ART.
Yeah. Lordship, may kindly take their approach. My case is both.
Yes. When the marriage was solemnized?
2014.
2014.
Yes.
What is the age of the petition number 1?
Number one.
Number 1 is
52.
husband.
Yes,
52. And 2?
On 18th June, cost 50.
Huh?
18th June 2026, she has cost 50. Age of
50.
50. Yes.
Then?
Lordship, there are so many judgments passed by this honorable court, whereas it is permissible after crossing of the age limit. After crossing of the age limit, the petitioner is entitled to.
That is one couple. One couple. If both the couple is crossed age limit, that is a judgment. If one couple cross the age limit, wife is underage, it's okay. Husband has crossed. Whether both the couple has crossed the age limit, where is the order? Show me.
No, sir. You not put the couple.
That's why the parties are coming to this court. Husband is overage, wife is not overage, but the authorities are not conducting as per the act. So the court has considered that yes, one person can also apply it for, and it can be done. But here both the parties are
not both the parties. Sir. Here petitioner number 1, the husband has
55
within age.
52.
It's 52.
The
wife has just crossed few days back.
Okay.
On 18th July.
When the marriage was solemnized, 2014.
2014.
Then there's no issue.
No.
After the marriage.
After the marriage, both the parties were trying availing assisted reproductive technology from 2016 till date. They have tried IVF for 2 times. One in 2000.
Why you have waited till the age of 50? If your marriage was solemnized 2014, now you are waiting for the 12 years.
They are trying for baby availing assisted reproductive technology service from 2016, sir.
That's why you kindly come to the page 14. There's 17 report. Page 14, you went under medical treatment on 2017 after 3 years of the marriage. Correct?
Yes, sir.
Then it will continue. Then it was till when? 17.
They have tried IVF on 2017 and again on 2019.
Where is?
Failed to achieve success.
Where is?
Page 16, sir.
Page 16.
Yes.
Page 16 is 2019. Yes. Pre-existing diabetes, mellitus, hypertension. Yes. Then
they have tried for another on 2019. Page 17, sir.
2019. This is nothing. Insulin.
This is in page 16, sir. 2019.
Yes, already.
Afterwards, they continued the treatment, and now they are trying to.
Where is the report? Where is the report? They are able to conceive.
Yes, sir.
Where is the report?
21.
They can go for the ART. Sir, your last report is 2019. Correct?
Yes.
And how the doctor can issue the certificate in 2026?
No, sir, we are continuing the treatment.
Where is continuation? 2017, then 2019, then 26.
The petitioner number 2, after the second miscarriage, has gone through neurological disorders. They are treating
And after
Where
curing the document, sir? Where is the documents? Where is the document?
Lordship may kindly fix, shortage date.
What?
Shortage date for.
Again, supplementary. All advocates are doing that.
Presently,
File the writ petition with 2 annexes. When the court started putting question, supplementary.
Lordship, what has happened, the treatment has stopped and the side effect also
I
started.
don't know where from you got this practice.
Lordship, treatment has stopped. Treatment.
The petition has filed affidavit of service. Let the same be kept with the record. None of inside the service, none appears on behalf of the respondents. Counsel for the petition prays for time to file supplementary affidavit. Let supplementary affidavit file within 1 week. Please the matter on 29 July 2026. Yes.
May it please your lordship. My lord, I am appearing virtually. Kindly permit me, my lord.
Yes.
Item 5 and 6, I'll not take more than 10 minutes, my lord. I have prepared, my lord, may I hand over a skeleton notes of submissions which I'll refer to while arguing, my lord, very briefly. And my lord, I'll quickly indicate what the matter is. My lord, my learned junior will hand over a copy.
Yes, written notes. Yes.
It is not the written notes, my lord, it is the skeleton notes of submissions, only for the purpose of, my lord, my indicating the points to the Honorable Court. My lord, very briefly, if your lordship takes up, my lord, the second page of the note, your lordship will find the background. Issue is very short, my lord. There was two work orders, office orders, my lord, which were issued by WBACDCL. My lord, may I quickly indicate where that document lies? Your lordship will kindly take up the second writ, item number 6. The second writ petition, my lord, page 387.
Page
387, my lord.
What is the number?
My lord, 5195 of 2026. 5195, my lord.
519. Yes. Yes.
My lord, page 387.
Yes.
Your lordship will kindly note, it starts from 387. My lord, at the top right-hand corner, office order number 2514.
Yes.
September 8, 2025. At page 389, clause 14. At the bottom, my lord. Page 389 at the bottom. Clause 14, litigation, arbitration against WBACDCL. Your lordship will be pleased to recall, my lord, this is the matter where there was a clause inserted in Form 11 which says any legal proceeding, if it is pending against WBACDCL, they will not be permitted to bid in the process. That's the challenge, my lord. So this clause 14 and this declaration we have to give in our letterhead, the bidders. That's clause 14, my lord. Your lordship will kindly take up the document at page 380.
380.
So at page 387 is one prayer and 380 is the next prayer. I'll quickly show my lord 380.
Yes.
Lordship will kindly see at the top right-hand corner, office order number 2518, same date, September 8, 2025.
Yes.
Form 11, my lord, is referred to in the third bullet point.
Yes.
Declaration regarding no litigation against WBACDCL.
Yes.
This Form 11, your lordship will find at page 383.
Yes.
383 is Form 11, my lord. This declaration has to be given in the letterhead of the bidder.
Yes.
It states, we hereby declare no legal litigation. There can't be an illegal litigation, my lord. Legal litigation or arbitration is pending ongoing against WBACDCL in any court forum against the bidder or its sister concern, director, partner, proprietor.
Yes.
This is a declaration which is expected of the bidder. This is under challenge, my lord. So I have challenged, we have challenged this and, my lord, the second office order. Now, one pleading I have to show to the Honorable Court, my lord, in this writ petition, paragraph 46.
So this is the only challenge.
This is only challenge, my lord. This is the only challenge.
Page 380.
380 and 387, my lord, at 389. These are two office orders, my lord. First is
what is the 389?
387, it starts, my lord, the second office. This is the first office order. 387.
What is 389? What is the 387? What is the
Well, this is the office order number 2514, which encapsulates in clause 14 at page 389. 389 is clause 14, my lord. Part of this office order.
Same thing. Okay.
Same, my lord.
Okay.
These two. Now, why the two, my lord? Why the second writ petition? We have stated at paragraph 46, page 28 of the writ petition, my lord. Page 28, paragraph 46. The first writ petition, my lord, we had challenged what is at page 380. When the submissions were being made, the other side produced this communication. So in this writ petition, we have challenged both, and we have disclosed this in paragraph 46 of page 28 of the writ petition, my lord. Now the notes, my lord. Very briefly, if your lordship takes up the skeleton notes.
Yes.
The second page.
Yes.
In the brief background of the facts in the proceeding, the second page, my lord.
Yes.
We have stated under paragraph 1, the first, my lord, we have stated that these two office orders, first bearing 2518 of 8 September, where they made a revised purchase policy and new forms were incorporated in the e-bid technical proposal, included Form 11, which related to a declaration regarding no litigation against WBSTC. We have given the page number, my lord, 380.
Yes.
1B, my lord, is page 383, that is Roman 11, my lord, Form 11.
Yes.
1C, my lord, is the office order number 251 for the second one, my lord. The last line we have indicated the page number 387 at page 389.
Correct.
This is what I have shown, my lord.
Yes.
And 1D, my lord, is where we have stated that we have challenged both these office orders. Prayers are at page 29 to 35 of this petition, my lord.
Yes.
And the pleading, my lord, as to why the second writ is at paragraph 46 of page 20. That's the last bold part, my lord, in the last line.
Okay.
Now, the issue before the Honorable Court is, my lord, I've tried to call out, that's paragraph 2, whether the said office orders which incorporate Form 11 in the tender documents and restrain the petitioner from participating in the tender merely because of litigation or arbitration which has been initiated by the petitioners against WBACTCL or pendency of such proceeding before the court or other forums is bad in law and has to be struck down, my lord. Now, the point of law is paragraph 3 in the notes, my lord. Paragraph 3, we have stated the first, my lord, 3A. This is in violation of sections 23, 28, and therefore section 10 of the Contract Act. My lord, may I quickly indicate the provisions? My lord, 3A1 is where stated this is in violation of section 23 of the Contract Act. Where section 23 of the Contract Act deals with what considerations and objects are lawful and which are not. We have stated there, my lord, in the bold part in 3A1 that this is clearly violation of fundamental rights and of section 41 of the Specific Relief Act. Because they are restraining me from initiating litigation,
yes,
enforcing my rights for any purpose. My lord, the next point 3A2 is that this is in violation of section 28 of the Contract Act, which is, my lord, agreements in restraint of legal proceedings are void. This is an agreement in restraint of legal proceedings that can't be argued against, my lord. Hence, we have challenged that this is in clear violation because, my lord, in bold we have indicated this is in the nature of a penal clause, which is a restraint on the legal proceedings. So they are penalizing us, hence also bad in law.
yes,
Now, my lord, Roman 3, we have only indicated restrictions imposed through the impugned office orders clearly do not have any rational nexus with the object of the procurement.
yes,
Nor would they be necessary for promoting competition, protection of public exchequer. It's been put to give protection to the respondents from litigation, which is not permissible in law. Now, the other provision we have stated is under Roman 4, section 10 of the Contract Act. Because section 10 is what agreements are contract. It states it has to have a lawful consideration. Our contention is, my lord, that this is not a lawful consideration at all when this kind of a restrictive clause is put in.
yes,
Now, under 3B, we have, my lord, culled out why Article 14 violation. That's 3B 1 and 2. 1, we say, my lord, that this office order, it creates a hostile classification. Your lordship will kindly mark that. I should have put it in bold. Hostile classification between bidders. This is, my lord, 3B 1. Article 14 is written, my lord.
yes,
There, my lord, the second line, my lord. There is a hostile classification between the bidders who have litigated against WBACTCL and those who have not, although both may be equally qualified. So if you are equally qualified, but it's a hostile classification. Under 2, my lord, the classification has no reasonable and rational nexus to the object of the tender, and it's over-inclusive. It covers any kind of litigation, my lord, billing dispute, writs, arbitration. In the present proceeding, my lord, there are MSME, my lord, arbitration proceedings which have been initiated. So this we say, my lord, it renders the clause as bad in law. Now, my lord, Roman 3, this is where we, my lord, encapsulate Article 19(1)(g), because it impairs the rights of the petitioner to conduct the business. And we say this is not fulfilling, my lord, the reasonable classification under 19(6). And hence it is bad because it's an irrelevant factor. My lord, now the judgments, 3 judgments I have referred to, my lord. The first, my lord, on the doctrine of providing a level playing field. Vinishima Technologies, my lord, my learned junior will hand over a copy. I'll not trouble your lordship with the entirety, my lord. I've indicated the paragraph numbers. We'll also hand over a copy to my learned senior friend, my lord. Vinishima Technologies, this is on the proposal, my lord. The Honorable Court here, my lord, had struck down the tender condition. My lord, here the facts were, my lord, the bidders who had supplied sports goods to, my lord, Chhattisgarh government agencies in the preceding 3 financial years, my lord, they were allowed to participate, rest of them were not allowed to participate. This clause was struck down by the Honorable Court by stating, my lord, that this is arbitrary, unreasonable, discriminatory, because no reasonable and rational nexus to the object of procuring sports kits were, my lord, provided. Hence, in violation of 14 and 19(1)(g). My lord, I have indicated the paragraphs. I will not trouble your lordship now. 13 to 22 I have indicated, my lord.
Yes.
Now the Eurasian doctrine, my lord, the classic judgment, I have just referred to it, my lord. Eurasian Equipment and Chemicals Limited versus State of West Bengal. This is where the Eurasian equipment principles were laid down by the Honorable Apex Court on the point of blacklisting of companies. May I hand over a copy through my junior? This judgment, I've indicated the paragraphs. Here, my lord, the court had held that an exclusion from dealing with government must follow a fair procedure and cannot be arbitrary. We have indicated this part, my lord, in the note. The principle laid down in this judgment, which are famously referred to as Eurasian Equipment Principles, have been followed time and again by the Honorable Courts in dealing with blacklisting matters and matters where right to trade with government are involved. This is very important, my lord, because I have argued in the conclusion that this is a deemed blacklisting for me. It's a penal clause and a deemed blacklisting for me because I have initiated proceedings against you. The next judgment, my lord, is the third, Kimberley Club. It's a very recent judgment, my lord. Kimberley Club versus Krishi Utpadan Mandi Parishad. May I hand over a copy?
Yes.
My lord, I've indicated paragraphs 10 to 13 and 18. Here, my lord, the tendering authorities, it was indicated that they cannot import unwritten conditions to disqualify the bids. Paragraph 10, essentially, my lord.
Yes.
That they have to adhere to fairness and transparency in disqualification criteria. In our case, and this is what I've written, my lord, in the notes. My lord, in our set of facts, written condition, my lord, is constitutionally suspect.
Yes.
Because it penalizes litigation. If I initiate litigation, that itself is a penalty.
Yes.
And this should be scrutinized and struck down by the Honorable Court because, my lord, of the principles laid down here.
Yes.
Now, may I sum up my conclusion very briefly, my lord? Kindly take up, my lord, the note, paragraph 5.
Yes.
My lord, first we say in paragraph 5, they should be struck down. The defense we have discussed, my lord, the defense taken by the respondents is that subsequent tenders we have participated. Of course, we were disqualified again. But it is argued that this is waiver or acquiescence. My lord, our contention is we filed a writ petition. We have tried, my lord, to participate. That is immaterial because we have always challenged this. So any subsequent participation where my lord, they have rejected is immaterial because we were apprehending if my lord, if it is allowed in our favor, then they have to then consider us in those tenders. Hence we participated. The second, my lord, 5B, we say the bar which is posed by the respondents through the impugned office orders are artificial barriers. Not kindly mark this, unrelated to technical capacity or financial soundness of the participant bidder. We say these conditions which are posed on us through the impugned office orders are not connected to the tender's objective, and they're designed to shield the litigation, my lord, respondents from any kind of litigation.
Yes.
Now 5C, my lord, the next point is these orders, my lord, the office orders, they axiomatically, my lord, exclude any litigation against WBSCDCL and is in the nature of de facto blacklisting without, this is why, my lord, the blacklisting Eurasian, my lord, equipment's judgment. It is a de facto blacklisting without notice, which clearly falls foul of the Eurasian equipment principles. And now, my lord, 5D, principles laid down by the courts that through these office orders, you know, they are violated. The no litigation clause is irrational. It uses a prior exercise of legal rights by the petitioners or participant bidders as a proxy for untrustworthiness with no empirical or logical basis, and hence it renders, my lord, these two office orders as bad in law, liable to be struck down.
Yes.
E, we have, my lord, summarized that litigation is sought to be penalized by them by keeping this clause. This is an absolute bar. And hence, my lord, we pray for rejection of these two, my lord, setting aside of these two office orders. This is in nutshell, my lord, my case before your lordship.
Thank you. That's
Very
all.
deeply obliged, my lord. That's all, my lord. That's all.
May I have a copy of the notes, man? Well, before
My lord, I have specifically requested my juniors not to hand it over because it's a skeleton notes, not an affidavit.
Very well.
No.
I have
Please,
understood.
Ridhiman, please hand over a copy.
I
Of
have
course, we
understood.
will hand over. My learned senior has asked for it, of course. It was on a lighter note, my lord. Of course, we'll hand it over.
The only difficulty is that the first limb of submissions, what I could gather, is that these tender conditions or these office orders are in violation of certain provisions of the Contract Act. Well, I have carefully perused the petition. Subject to correction by Mr. Bagh, I will stand corrected, ma'am. There is no such pleading and there is no such ground taken in the writ petition. So, my lord, even in the affidavit in reply, no such ground has been taken. So, my lord, the first limb of submissions, in my most respectful submission before your lordship, are not required to be even addressed to. Be that as it may, even assuming, though not admitting, that these arguments can be taken at this stage, my lord, tender is merely an invitation to offer. It leads to formation of contract. Only after formation of contract, my lord, violation of section 23 and 28 can arise. So, my lord, it is not gainsaid on behalf of the petitioner that the tender conditions are violative of section 23 and 28 because there is no contract as such.
No, their contact, but their contention is that the condition which you have put.
Yes. But they are challenging
the
the office order.
litigation is pending.
Right.
If any litigation is pending against the WBSCDCL, so nobody can apply for it.
Right.
So it cannot be said that is a violation of principle.
But I can understand, my lord, the violation of Article 14.
Correct.
I will address that because that's an issue which I am required to address. But so far as for these section provisions of the Contract Act, in the absence of pleading.
Okay, I will consider. First, you satisfy this code. How this condition can remain in the contract?
Right. In the tender.
In the tender.
My lord, kindly take the office orders for once. But today, my lord, your lordship will grant me leave to address on the judgments because I have to go through the judgments. But I am giving your lordship a brief outline of my submissions. Kindly take, my lord, the office orders, which your lordship will find at pages
380 first.
380. Well, rather, your lordship may kindly take 387 first.
Okay.
That's the first office order. 380 is the consequential office order. But 387 is the revision of the purchase policy or the procurement policy of, my lord, the respondent before your lordship.
Yes.
Kindly, my lord, take clause 14, which is at page 389.
Yes.
Litigation arbitration against WBSCDCL newly inserted. The bidder should submit the declaration in the prescribed format under the form folder form 11 in their letterhead regarding to regarding no litigation, legal litigation, it should be litigation against WBSDCL is pending in any court or forum against or by the bidder or its sister concern, director, partner, or proprietor. If any type of legal litigation or arbitration against WBSDCL is pending in any court or forum against or by the bidder or its sister concern, director, partner, or proprietor, then purchaser reserves his right to reject the bid, their bid, or terminate the contract. Now, the clause 15 is not relevant. In my respectful submission before Lordship, this policy, my Lordship will kindly visualize the activities being undertaken by WBSEDCL. The WBSEDCL, being an electricity distribution company, is rendering essential services. There can be any dispute to the fact. The supplies which are affected or the contracts which are required to be, works contracts which are required to be executed pursuant to the tender and acceptance of the bid are in the nature of infrastructure projects. And my lord, infrastructure projects regarding my lord distribution of electricity. These office orders are in fact, my lord, have been issued in public interest to, my lord, ease out or iron out the creases in the process of, my lord, execution of the contract in question. Now, the first question I raised, that the policy has been framed in public interest, having regard to the essential services rendered by the answering respondent. But I will also prepare a skeleton note so that, my lord, or I can add a little bit of flesh to it. So, my lord, the policy has been framed to examine and assess. This is there in my pleadings also. Examine and assess the litigation history of the participants in the tender process and arrive at a logical conclusion at the stage of evaluating the technical bids as to whether award of contract to such bidders would facilitate or impede the execution of works. In any event, any procurement policy is in the nature of a commercial or economic policy of state within the meaning of Article 12. So, when it is an economic policy, the lordships have held time and again, the lordships have always been circumspect about interfering with such policies unless and until it offends Article 14 or, the Article 19(1)(g), 21, etc., etc. So, now, question arises before lordship is that whether seeking a litigation history of a participant, and the assessment of the eligibility of a tenderer on the basis of litigation history, is it a condition which is so arbitrary so as to attract judicial review under Article 226 of the Constitution or not? These are the outlines. Next outline would be, my lord, I have in my affidavit, I have given a table at page 48 of the affidavit in opposition that, my lord, several other power distribution or power development or power generation companies of different other states,
yes,
have, my lord, this kind of condition embedded in their tender. Next, kindly also, I would beseech your lordship, subject to your lordship's kind consideration, also take page 63. Your lordship will find that it is not me alone. This petitioner before lordship is in, my lord, what should I say, my lord, is in, has been in litigation with several other electricity and distribution companies and with 2 distribution companies which have imposed this kind of condition. Kindly, my lord, take note of page 63. Next, my lord, it is their case. Your lordship will find the exact chart we have given.
yes.
Exact chart is being given at annexure, being annexure R4 at page 63. So, my lord, your lordship will find, but be that as it may, my lord, it is, this provision has been introduced not to target any individual or target any particular supplier. It is applicable to one and all. Anybody who has any litigation history has to disclose, and my lord has to come forward with the whatever is available on record. We have 137 suppliers, which are MSMEs. Out of 137 suppliers, my lord, unfortunately, my lord, this is the only supplier who is in litigation with us. Now, my lord, kindly, my lord, I will take your lordship to several judgments. Kindly, my lord, I'm giving your lordship the citations. My lord, lordship will kindly allow me to go through their judgment and also come back. My lord, first would be, my lord, 2013, 6 SCC 616.
2023.
No, my lord, 6. I'm sorry, my lord, 6.
2026.
2013, 6 SCC 616.
2013.
6 SCC 616.
Yes.
2003 2
2003 2.
APLJ
APLG.
431. Well, I have hand over copies to your lordship today. My lord, lordship will permit me to make elaborate submissions on the next available date. Then, my lord, obviously, my lord, Tata Cellular, which is 1994, 6 SCC 651. Then, my lord, Bajaj Hindustan versus Sir Shadilal Enterprises. My lord, the delicensing of sugar industry, your lordship will recollect that's a landmark judgment.
Yes.
2011 1 SCC 640. Then, my lord, the Federation of Hajj PTOs of India, 2020 18 SCC 527. 18 SCC 527. So, my lord, these are the judgments which I would rely on.
Yes.
And, my lord, kindly, my lord, allow us to make elaborate submissions on the next day. I will not take more than 10, 15, 20 minutes. I will place these judgments. But I believe, my lord, your lordship has a matter at 12 or something like that. So, lordship will kindly give us a short date. I can come back.
My lord, may I only indicate one fact, my lord? My learned senior friend has just indicated that if there's a disclosure of history of litigation, then that would not be, my lord, here it is not about disclosure, and I'll indicate to your lordship why perhaps that, my lord, submission is being made. There's a judgment of a division bench of Delhi High Court, my lord, ME Infra Projects Private Limited, where this was upheld by the, my lord, Bombay High Court on the point that if there's a disclosure asked for of the litigation history, that will not make the tender bad. That is neither here nor there, my lord, with these facts. I'll indicate that judgment
got
also.
me wrong. It is not my submission. My submission is that if there is any litigation history, I have the right to reject the bid. But this is my case before lordship. In any event, my lord, in fact, my lord, we can, your lordship, any date, my lord, a short date, my lord.
Any interim order?
And my lord, no, there is no interim order. My lord, only
There's
one.
an interim order, my lord. An interim order is continuing, my lord. The interim order is continuing.
Own interim order ache? No, I think Mr. Bal.
No, I'm sorry. There's no interim order.
He
There's no
gets
interim
interim orders in every court, every matter. So, my lord, he has forgotten where he has not got any. My lord, only one thing. I believe, my lord, in this matter, Union of India and state are also respondents. So, presence of state would be necessary because we are
The state is not appearing in any matters.
not appearing in
Any matter before this court. If
Before
they
your
are
lordship.
also,
We
they are
have
not-
served them, my lord. On the last day also, it had fallen from my learned senior
They
friend.
are
It's served.
appearing also, they are not getting any instructions from the state.
You have served them.
As far as my practical knowledge goes, sitting in this court.
Well, that's not so happy, my lord.
That's why every day I have to tell the all advocates, the state advocates, but because I have called the GP also, they're not, even I call the legal remembrance also before this court. Nil, result
But
is
in
nil.
some matters, they are present.
That's why I am taking the affidavit of service, I am disposing of the
Very
matter.
well. This is just to assist your lordship. Kindly give us a date, we will come back.
Nobody is assisting before this court from on behalf of the state. What can be done?
Well, should we hand up the copies? We will hand up the
Learned
copies of
counsel
the
for the
judgments on the
petitioner
next day.
concluded his argument, full stop. And counsel for the respondents argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear. On 22nd July.
22nd July. Wednesday.
22nd is Wednesday.
Wednesday.
22nd July within 5 minutes.
If there is any difficulty, I will come and mention and
Within
well,
5
because
minutes.
I will not well,
No problem.
your lordship's well, or lordship's docket is well,
That is the
it's
problem.
an overload, exploding docket.
I'm very deeply obliged, my lord. Very deeply obliged.
Yes, next.
Affidavit of service, man.
Affidavit of service kept with that. Yes, next.
I'm grateful.
Lord,
I'm being led by Mr. Kishore Dutta in
Yes.
this matter.
Lord, I'm for the respondent.
Yes.
Lord, in this matter, there was an appeal preferred by my client, which has been, kindly see this order.
Yes.
The appeal was partly heard there, and then your lordship was disposed of the, released the appeal. So, Lord, I have to take my, have to,
We have preferred an application for reimposition of the interim stay order, which was allowed by your lordship on the last occasion, that is 12th of June. And the interim order was reimposed, and it is still today, lordship. In the meantime, the appeal.
You have not got any stay with from the appellant?
No, lordship.
no, I'm to apply for, but
Other court.
the other, because the other appeal was pending in the list of court number 8.
Okay.
So it has to be tagged.
Okay.
So there is a section 5 application in this appeal, which my learned senior has preferred. We have filed our.
No, not here. That is
That is not here. That
Yes,
is
lordship.
that-
I'm just intimating that.
that is another matter. Another matter.
Mr. Ajay Krishna Chatterjee, learned senior advocate, appearing for the respondent, submit that the respondents have preferred an appeal before the appellate court.
Your lordship.
And on 7th of July 2026, the appeal was taken up for hearing, but the honorable court has released the matter, and now the learned advocate for the appellant will take appropriate step for mentioning the matter, assigning the matter before the appropriate court. So, learned counsel for the petition submit that the interim order is still today and paid for extension of interim order.
Yes, lordship.
In view of the submission made by the counsel for the parties, the interim order is extended.
I will come back. Either way, if it is decided, I have to come here.
And extended till 4th of August 2026. Until further, yes,
We will make the best of effort.
or
to
until
have it.
further order, whichever is earlier.
We shall
Let
show
the-
this order before the court for urgency.
Let the matter appear on 4th August.
Great.
Gratefully, your lordship. Your lordship,
Under the same heading,
your lordship.
under the adjourn motion. Adjourn motion, under the adjourn motion. Yes. It's anything, any.
So I don't want to add anything, but the only concern was
Yes.
extension of interim order.
That granted, and they preferred an appeal, let us see. Yes, next. Back.
My lord, Mr. Farhan Bangabadhe is appearing in this matter.
Writ petitioner.
He is appearing for the state. My lord, I have the instruction, but he has his legs on court number 2. Kindly going for short passage, short
Some
passage.
serious issue, my lord.
Yes.
This is under the Transplantation of Human Organs and Tissues Act 1994.
Hmm.
My lord, we have complied with all the provisions
Hmm.
because, my lord, I'll just indicate, my lord, kindly takes the writ petition and lordship will straight away come to, my lord, page 26. My lord, the act mandates under section 9 and the rules, my lord, that the recipient of the organ and, my lord, the donor to jointly submit an application to the authorization committee. My lord, the authorization committee, my lord, thereafter scrutinizes, my lord, the credibility of the recipient as well as the donor, and then, my lord, the authorization committee gives the necessary approval and the sanction to proceed with the surgery for transplantation of the human organ. Here, my lord, what has happened, my lord, all the requisites have been complied with, but, my lord, the difficulty that we are facing is, my lord, page 62 and page,
What is the organ? Kidney?
yes, kidney. But this is, my lord, I am.
The police investigation was, inquiry was carried out.
No, my lord, because under the act, my lord, the donor has to go to the hospital and the donor has to face
Now,
the.
who is the donor?
The donor is a near relative. The donor, I
Correct.
believe, is represented. My lord, the respondent number
Yes,
number
I
7
am
is
for
the
the
donor.
7.
But donor is a near relative. Donor has filed an affidavit. Donor's father has filed an affidavit that the donor is ready and willing, my lord, to donate the kidney. And my lord, the application for approval of transplantation has also been jointly signed and in terms of the mandate of the act and the rules by the recipient and the donor itself. That is the reason why, my lord, I had
What is
drawn.
the rejection? Why not
Yes,
rejected?
kindly see, my lord, page 63 first. Page 63, this is the order of 19th of June 2026.
Relied upon my order only. Yes.
Yes, no, I am relying on that. Malad, 19th of June 2026, page 63.
Yes.
Malad, the only one line, kindly see, this is for information that the prayer for issuance of permission for kidney transplantation of the recipient, Mr. Such and Such, from the donor, Mrs. Such and Such, has not been recommended by the State Authorization Committee at the board meeting held on 9th of June on the basis of unfavorable report from the district level verification committee. Now, my lord, there is, I believe that there is an internal unfavorable
That's
report,
I'm telling.
but that has not given to me. What they have done, my lord, they have uploaded a list in the portal of the West Bengal government's health department. That portal of the list is at page 62. I am serial number 9.
Yes.
I am serial number 9.
Yes.
The institute that will be
Not
performing
recommended due to unfavorable.
unfavorable report. My lord, I am not aware of this unfavorable report. Today, my lord, the matter is here. My lord, if the state, my lord,
That's
if
why
they
that's why
hand up the unfavorable report,
what till date what I got from the respondent authority, it is all the things what you are submitting the document with regard to if the donor is the outsider or relative, then the report is required, and this report consisting of the financial implications, whether the financial has been. So the police verification is to be done. Report has to be taken whether for this any financial transaction has been made or not, or what is the financial condition of the donor or not. That is to be taken into consideration. Let they file the report. How soon you will file the report? Report is there.
may I get a copy of this?
Let me see. Let me see.
Operating portion is number 9.
Page number 9.
Not recording the blood relation.
Not mandatory.
I got it.
Yes, give the copy to. Give the copy. Clause 9. Kindly page 9, clause 9.
Page 9, or I'll just.
Page 9, clause 3, 4, 9, and 11.
Husband of the-
No possibility of the official dealing. Could be, what is this? Nothing could, what? Kindly come to the page 11. Not having the report. Take this.
Yes, sir, I'll get it.
Come to the page 11. Yes. This is a report submitted by the police authority during in. Can you see the 1, 2, 3? There is no blood relation. Okay, with the donor, no problem. Could be established. No problem. No possibility of official dealing. What is the official dealing to establish? Could be established. What is official dealing? And nothing could be established. What nothing could be established?
I need instruction from my senior that
And then may it appear in your lordship's list tomorrow because there is some urgency, my lord, life and death situation.
No, I appreciate.
Yes, my lord, my learned friend.
You are appearing.
I tender.
Yes. You come to the page 11 because this is the report submitted by the
There
police.
is no blood relation.
That is different thing. Blood relation is not required. Now kindly come to the 2. No possibility of official dealing could be. So what is the official dealing could be established? What is the meaning of this? And what is the 3? Nothing could be established. What is this? See, I am fixing after a week, you take a report from the police authority to inquire whether any financial transaction has been made between the donor and the recipient.
My lord, that is already been given. There is no such
No such. So that's your report is not clear. Kindly come to the 9. Kindly come to the 9.
Yes.
On the basis of which the authority has rejected. Kindly come to the 9.
It is now clear how both the parties came into contract, hereby the family, friends, or driver. The petitioner is residing in Howrah, and the donor is residing in North 24 Pargana, my lord.
So that's why not. See, that's why only we have to see with regard to any financial money transaction is done with regard to transfer of the organ. So that's it cannot be a business.
Page 7,
cannot be a business.
My lord, all the report kindly come to page 7, my lord.
Yes.
1. Local police verification report to rule out the clearly stating that there is no financial transaction, no middleman involved.
So
this is urgently needed, my lord. Regarding financial transaction, my lord, they have given a report, my lord.
Report ruled out the clearly. So this is urgently needed. What?
Against it.
Local police verification report to rule out the clearly stating no financial. Where is that report?
Report is not annexed here, my lord. I will annex the report, my lord. Kindly, my lord.
That is, I recall, the court want that only. With regard to all the things, the authority will see. Only to avoid any financial transaction for making a business for with regard to the transplantation of the human organ. So it should not be a business.
Understood. I will duly confirm.
When?
Next week, my lord.
Come, it is a serious matter.
My lord, Tuesday, make it on Tuesday, my lord.
14th.
14th.
Learned Counsel for the state has filed the report. But from the report, it is found that it is recorded. It is found that it is recorded that the local police verification report to rule out clearly by stating that there is no financial transaction and middleman involved is required. But the report submitted by the state authority does not reveal any such report has been considered by the authority by rejecting the request of the petitioner. Accordingly, Learned Counsel for the state prays for time to place the report before this court. Let the matter appear on 14th July.
Madam, may I make a request, madam? May it appear as a 2 p.m. fixed matter on 14th July?
2 p.m. then it will go September. Within 10 matters.
First, but the report that has been used today, may I get a copy of the report?
You the copy. Great. Next.
May it please your lordship, my lord. Lord, I am for the petitioner.
Yes.
But this is my affidavit of service. Very unfortunate incident.
But debarrer, my lord, petition is not maintainable.
That will allow me to.
No, debarrer point has been taken first.
Yes. Well, let me enlighten your lordship.
The fighting between the bar members.
No. It is not. It is not. Kotha, eta kotha. Affidavit of service ta koi. Diye de. My lord, sorry, my lord. It is not like. Your lordship will allow me to enlighten the facts. My lord, this petitioner happens to be made a scapegoat in a rivalry, my lord. Previously, it started with the erstwhile dispensation and thereafter with the police authorities and thereafter with the entire Rampur Bar Association. Now, my lord, this petitioner happened to be, my lord, serving the country in the army and was...
In the army?
Yes.
The petitioner?
This petitioner.
Then?
And thereafter, my lord, he was awarded with bravery awards that your lordship will find in the annexure, my lord. Now, post-retirement, my lord, he was taken shelter to his home, native home, and he, my lord, started social activities. Now, what happens, my lord, once he starts taking these records by helping pro bono to the villagers who had a lot of problems, my lord, the police authorities started, my lord, in connivance, initiating false cases. Be that as it may. My lord will find that 4 cases were initiated if your lordship comes to page 6 once. A, B, C, D. These are the 4 cases, false cases, which were initiated. Now, my lord, These 4 cases were handed over to one advocate, that is respondent number 13, to look after the case. Now, all along he was looking, so far as one case, my lord, when he was not satisfied, he asked for a change. So accordingly, my lord, he gave a change, but he did not give a change in respect of a particular case. That was GR case. Now, suddenly, one upon inquiry, my lord, he was repeatedly saying that when is the date next fixed, he was not informing. Suddenly, a day before, 30th of December 2025, this gentleman 13 gives a call to the near relative and says that the next date is posted tomorrow. This petitioner, my lord, hurriedly, my lord, goes to the court. Before that, he goes to his chamber. He says that I am present, but it was not possible for his son, who is a resident of Mumbai. So you kindly take steps. Your lordship knows, is aware of the criminal procedure, my lord. If someone is not present, 317 CRPC. He assures him, and thereafter they go to the court of law. And when the ACGM, that court calls the matter, the presence is made by the petitioner, my lord. And so far as this son of the petitioner, no steps were taken. So accordingly, a warrant of arrest has been issued. After that, he comes off the court and he inquires that why such warrant of arrest, why didn't you take any steps? He was taken to his library. There were 4 other advocates who are all respondents to the effect. Now they start, my lord, threatening him. He, being a senior citizen, my lord, he says that this is not the age when I have already paid your remuneration. My son should not have been affected by this order. My lord, he is physically assaulted. There is a CCTV camera. I tell your lordship, there is a physically assaulted. My lord, thereafter, once the matter gets worse, he is taken to the hospital. In the meantime, because they are the learned advocates, they go before the court and they call the police and he's arrested on 30th. This is not the end. Now, on 30th December, this gentleman has been taken to the hospital first for his assault, and thereafter he is taken to the custody. Thereafter, the respondent number 10 takes a resolution that no one is supposed to appear for this petitioner in the court of law. My lord, accordingly, my lord, no one could appear, neither the court officers nor the, my lord, the department. They did not, my lord, issue any certified copy. So from 30th of December, no steps were being taken. The family members of the petitioner were running post to pillar. No one, my lord, was cooperating. Ultimately, my lord, upon compulsion, my lord, they had to come to Honorable High Court at Calcutta to engage an advocate. And why I say that, my lord, I was the person who took the responsibility of attending Rampurhat Court. I personally went along with my juniors, my lord. On that day, when a put-up application, your lordship knows, because the date was not fixed, the put-up application was filed before the court below. My lord, a resolution was passed that one of our learned friend has expired. So on that regard, everyone came. You are not supposed to appear. I said, very well. I bowed down before the court. I said, I will not appear. Kindly keep this pending. I'll come another day. From here to Rampurhat Court, your lordship can understand. Now, thereafter, my lord, the next date which was fixed, my lord, now your lordship takes the order. I'll trouble you, I'll beseech your lordship, my lord.
So what has happened? Then you appeared.
Yes, I appeared. Again, the same situation arisen that the bar has taken a resolution that no one can appear.
Correct.
My humble submission before this court was that if the bar members of this court are aggrieved, they might not appear. But an advocate who is coming from other courts can appear. So that was also resisted by them. Anyway, on 27th January 2026, since 30th, my lord, ultimately the learned ACGM was pleased enough to hear the bail application. Your lordship kindly takes that bail application once.
So what do you challenge?
I have challenged, my lord, that since, my lord, I was affected, my lord, in spite of the bail order. My lord, I was detained in the custody because no one was allowed to give a surety bond before the court of law. My lord will kindly take the order first.
Yes. Which order? Order number?
My lord, that is at page.
To registered surety. Page 33.
Yes. Just once, my lord. I'll trouble your lordship. 31 it starts. My lord, may I read, my lord? This is very important. The bail petition filed on behalf of the accused is taken up for hearing. During hearing, learned lawyer for the accused, namely Mohammed, it has been wrongly, my lord, the name has been taken for the accused by the inter alia submitted before this court that the said Shaukat Ali is in judicial custody since 30th of December 2025. According to him, the accused is in custody for about 28 days, but his bail petition was not considered by this court on 16th of January 2026. From the case record, I find that as the CD was not available on that date, and as such, if there was any ingredients of offense under section 109(1) BNS could not be looked into by this court, and as such, the bail payer was rejected by this court. As per previous order, as the date was fixed on 27th of January 2026, the CD was called for on that date. Learned lawyer also submitted that though the urgent certified copy was applied for on behalf of the accused person on 16th of January, but till today it was not provided to them. Also, I find that the Wakalatnama was accepted by Mohammad Arsalan, learned advocate practicing in the Honorable High Court. At this stage, learned Secretary of the Rampur Bar Association, Advocate Utpal Mukherjee, submitted that the accused person has assaulted learned advocate of this bar association and abused him with filthy language, for which it is an assault towards the learned lawyers practicing in this court, and as such, bail petition should not be allowed in favor of the accused. The complainant is also learned advocate practicing before this court who vehemently opposed the prayer for bail. On behalf of the Bar Association, Advocate Abhishek Banerjee drew the attention of this court towards the Wakalatnama submitted by Mohammad Arsalan, advocate for the accused person. He pointed out that the Wakalatnama, whether has been filed by any advocate approved by the Bar Council of West Bengal or whether the said accused Shaukat Ali appointed such lawyer to plead for him is not confirmed as yet, and the confirmation from the controller Rampurhat Sub-Correctional Home is yet to come in this case record. In reply, the learned senior counsel submitted that he will file the relevant documents, and subsequently he filed a copy of the enrollment certificate in favor of Mohammad Arsalan, the advocate on record, and also he filed a copy of the identity card issued by the Bar Association of the Honorable High Court in favor of Mohammad Arsalan, who is the son of such and such. Learned lawyers for the Bar Association Rampur had pointed out to the fact that the defense counsel used the Wakalatnama from the Rampurhat Bar Association when the said organization are not the members of such Bar Association, which according to them is quite illegal. I differ with the submission of the advocates of Rampurhat Bar Association in this respect. A member of the Bar Council of West Bengal is empowered to move and plead before any courts in West Bengal and also before the Honorable Supreme Court of India. To plead before any other court other than High Court, only the council is required to submit a Wakalatnama procured from the local Bar Association. Now the only question remains that the accused Shaukat Ali validly appointed the learned defense counsel to plead for him. From the front part of the Wakalatnama submitted on behalf of the accused person, I find that the signature of accused Shaukat Ali is attested by the controller of the Rampurhat Sub-Correctional Home. So there is no doubt that he authorized Mohammad Arsalan to become his lawyer. After comparing the memo of arrest dated 30th of December 2025 with the Wakalatnama, I find that the signature of the accused is same and identical one. So I find that there is no doubt that the accused appointed Mohammad Arsalan to become his lawyer. Accordingly, the power of Mohammad Arsalan, learned advocate for the accused, is hereby accepted. Learned Defense Counsel submitted before this court that this case is registered under section 329(3) of the BNS, which is the offense of criminal trespass. As the place of occurrences of the incident of the court premises, which is public place where everybody has the right to remain, who have litigation, and as such, this section is irrelevant. Likewise, he also submitted sections 115(2), 109(1), 132, 221, 351(2) of BNS are not applicable to this case. As this case is a premature stage, so it is hardly possible for this court to comment on this regard. On perusal of the case docket, I find there are statements of several lawyers recorded under 180 of BNS. Besides that, there is no injury report suggesting that the victim or the complainant was assaulted by the accused person to such severity to suggest or attract offense under section 109(1) of the BNS. On the other hand, from the medical certificate of the accused person issued by the Chakmonda BPHC dated 30/12/2005, I find that the accused had undergone angioplasty for 2 times in 2018 and 2021, and he was referred to the Calcutta for heart problem, and several medications have been prescribed to him, and he was referred to Rampurhat SD Hospital. On 21st January 2026, I went for inspection, the judge, for inspection to Rampurhat Correctional Home, and I met the accused along with other accused persons. I found both his legs were swelled and he is unable to walk. 2 persons helped him to bring him before me, and his health condition is serious. So considering all aspects, I am of the view that for humanitarian consideration, the interim bail in favor of the accused should be allowed with some conditions which has to fulfill. Now, my lord, this is the situation. Your lordship will kindly see what has happened. Immediately thereafter, once an ad interim bail is, my lord, granted in favor of the petitioner, my lord, I approach the people who can give a surety so far as the bond is concerned. My lord, there is a resolution, they say, the secretary of the bar, respondent number 10, that no one will even give the surety, no one will be assisting him so far as this part is concerned. My lord, they compel the petitioner's son to give a letter. Kindly comes to page 34 once. I have gone to the secretary also. Kindly see the letter. I, Sarfaraz Ali, son of Saukat Ali of village such and such, do hereby through his letter request to all the learned members of the Bar Association Rampurhat Court that according to the order dated, passed by the learned additional chief judicial magistrate Rampurhat Court, wherever the learned court was to please to grant interim well to my father, Saukat Ali, with condition to furnish through registered surety attached to this learned court. I make a request, the learned bar, that I may be allowed to present before all of you so that his bar allows me to furnish 2 registered surety as per the direction of the learned additional chief judicial magistrate Rampurhat Court. I would be deeply obliged if it is allowed. Now, my lord, as per law, my lord, no one is coming forward, my lord, in spite of a bail being granted in my favor. Now, my lord, the next step was that as per the BNS, my lord, I have a provision where I can go before the learned judge and make an application saying that personal bond. Kindly comes to the next page, page 36. Yes. This is in the above noted case an enlarged PR bond of rupees such and such. So, my lord, after this application was filed, my lord, ultimately this was considered. Now your lordship will find a certified copy of the order which has been annexed, page 41. Your lordship comes to the 3rd paragraph. In such on the view that the accused Shaukat Ali be released from the JC on furnishing PR bond of rupees 5,000 with him, with condition to cooperate with the investigation and personally meet the investigating officer twice in every month. So, my lord, this is allowed because, my lord, this is the situation to even to obtain a certified copy, my lord. There is a direction to the department that no copy should be given to this accused. Your lordship can call for the records and your lordship will find what has happened.
So now what you want here?
Now, my lord, your lordship takes the prayer. My lord, in spite of, my lord, first of all, the complaint. Now, my lord, this is very important. I must say, what was the complaint against me? This is very important.
What is the prayer? What
Prayer, my lord.
the read?
Page 20.
20, my lord.
At 21.
21. B, C, D, E, F, G.
Have you made a complaint to the bar council?
My lord, yes. 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 Okay. My lord, the situation is till date, my lord, this petitioner, my lord, so far as the situation there, my lord, he is restricted from, my lord, appearing before the court of law with deepest respect. My lord, the advocates who are looking after, they have been threatened. My lord, if they say there is a resolution, my lord, I, with deepest respect, my lord, my learned senior friend knows that I was also holding, my lord, I was the person along with my president and secretary went to the Supreme Court and gave an undertaking. My lord, your lordship will consider that these type of resolutions, my lord, from the bar, when they say,
take it from me, there is no resolution.
then my lord will kindly,
Okay,
no. If there is no resolution, then my lord, it has been recorded by the judge.
Let they file the affidavit.
Yes.
Let they file the
Yes.
affidavit.
Yes.
Petition is maintainable, my lord.
Yes.
I will certainly, my lord asked me, I will file an affidavit. But the petition, the prayer is made, is maintainable.
Yes.
Made, but Mr. Basu, you are much senior from all of us. Can the advocates restrain anybody not to appear in the court?
Certainly not.
Or whether the
Certainly
petition
not.
then
Before my lord,
so I ask you, who are you? In my court, please maintain the decorum.
straight answer is no.
Then, if it is not, why the petitioner was in custody and okay, you made a complaint, there was a personal, whatever it is, whatever you made a complaint, police stated, this court is not going into that. Can the person be remain in custody because of the bar resolution or
That is
bar
not resolution at all.
bar
But
condition?
here I will not take the name. One person, one senior advocate was accused in a proceeding. A proceeding was initiated against him. We, the entire bar, thought we will not appear.
Correct.
this is my personal,
That
my personal
personal
thing.
is different
If there is a
thing.
resolution, my lord, certainly
Personal is
condemn it.
different thing.
There is no resolution.
Personal is different thing. That's you come with the affidavit.
is
Come
no
with the
resolution.
affidavit. Yeah, there is no resolution, and it
If
is
there is
our
resolution,
person.
they should have annexed it.
Let you
That
come.
I have pleading is there. They have not
Reading is
supplied.
there. I will. But
That's why. If
I'm
it
not
is
high on
not,
that.
if it
But
is
keep
not,
this point open. I take it from me because of the bar matter, my lord, I will be there.
no,
So,
that's
whatever
our
bar.
matter, sir.
So,
You how
he
far
knows
you,
very well.
how far you are seniors, I am also serious with regard to the bar matter.
Yes,
Correct.
certainly. Because if
Well, am I not a part of a bar?
that's
No,
why
I
he
am-
knows me very well. So, if there is any resolution, I am the last person to appear before my lord.
Because what has happened
I have
in
categorically asked, is there a resolution?
And my lord, he knows.
Second part should not have been. Supreme Court cannot direct any lawyer to appear. This is his prerogative, whether he will appear or not appear.
My learned friend should not disbelieve me at least.
I am not.
When I say that I have been
the
there.
client. Had it been any,
And he
the
knows,
first thing I
with
asked,
deepest respect, when I was there in the bar, my lord, I had gone to the Supreme Court.
But
and
live
given an
aside, whatever you please
first
see.
thing I asked,
Mr. Basu, your senior member, see all the things can be
the first
settled.
thing
All
I
clients are coming and going,
Yes.
whatever it is.
first thing I asked, is there a resolution from you? Answer was no, there is no resolution.
Let you file the affidavit. That
I
can
will.
be
I
disposed
will.
of.
Only
nothing
to that
else.
extent, nothing else.
Nothing.
This whole entire thing, BSNL, I cannot, this court cannot go into the merits of this criminal proceeding.
No, I'm not saying that criminal proceeding, my lord. I say that, my lord, I have a right, my lord, your lordship knows. Once, even after such harassment, bail was
Correct.
granted.
That's why now only to see if they have taken the resolution, then the court has to
And then
interfere.
what makes me, my lord, make an application? They compel me to prefer an application.
What?
I've shown that letter.
What?
They say that you have to make
Correct.
that application.
But they,
That's why if that application has been given, let they file, let they give all that
But only
deal
one
with that.
resolution. One,
take it from me.
only one indulgence.
This court find that the writ petition is to be decided only after the affidavit is filed by the respondents. Oh, respond number?
My lord,
I am for the bar association.
10, you are respondent number 10.
10 onwards.
10.
11, 12.
Yeah, state is nothing to do.
10, 11, 12.
For the affidavit is required to be filed by the respondent number 10 and its respondent number 10. Let the affidavit
Or
file
can you indicate that whether there is a resolution passed or not?
by indicating that whether the bar has taken any resolution,
As alleged in the writ petition.
whether the bar has taken any resolution for not appearing to defend the petitioner in the criminal case as alleged by the petitioner in the present date application, and whether the bar has directed the son of the petitioner to give a requisition letter for providing the registered surety in terms of the order passed by the London magistrate while granting.
Only one indulgence I will pray before your lordship. Kindly analyze the situation. Because my learned senior friend is not still today, only one protection to the petitioner because he has to attend court. Rightly, wrongly, whatever the case is. The situation is some protection to be given to him. I tell your lordship, I have seen.
Okay, if now the writ is here, Mr. Basu is here.
Only one line of protection.
If anything is come, you come. I will take your matter.
I'm so grateful. I'm so grateful.
I will put
Within one
put in
2
task,
weeks.
Mr. I will put Mr. Basu in task.
Within 2 weeks.
Yes, before that.
Within 2 weeks. Reply if any there to be filed within a week thereafter. Release the matter on 5th of August.
I'm so grateful.
Under the
Sorry to
same
trouble your lordship.
affidavit kari dena.
Grateful to my.
So grateful.
Lord, I beg to appear on behalf of the petition. Now, my lord, as per the tender, my lord, my tender has been accepted. If your
Tender has
lordship
been
accepted and work
accepted.
order has been issued. My lord, kindly
Correct.
have a look, page 24. 24, 25, 26. 3 tenders, 3 stations for my lord parking lot. Now, my lord, I am
doing my job after the tender. Then, my lord, it was, my lord, issued on in the year 2024, 30th September 2024. If your lordship kindly have a look, page 24. This was the acceptance of tender.
This is a work order.
Work order.
Issued to you.
Yes.
What is the nature of work?
Well, this is for
Operation of
parking
two-wheeler
lot.
parking.
Yes.
At the
Cycle and
Bishnupuriya
motorcycle.
Salt Railway.
Yes, my lord, this is very vital. Next page, my lord, kindly take trouble, my lord. Purvostoli. My lord, first line. Purvostoli railway station. My lord, got it.
Yes.
Next, my lord.
Navadip Dham.
Second line. 3 different stations, 3 tenders.
5 years. 3.
Then, my lord, 3 separate, my lord, work orders. Now, my lord, in a single work order, my lord, page 27. If your lordship kindly take trouble.
Yes, come.
My lord, this is the 3 tenders, separate tenders, but in one letter, my lord, this I have been, my lord, without any opportunity, my lord, my tender has been, my lord, contract has been cancelled. My lord, kindly have a look, the second paragraph. It has been observed that the repeated complaints of serious nature have been received against the functioning and conduct of the licensee. The acts reported are found to be contrary to the acceptance business practice and constitute violation of the terms and conditions of the contract, including clause 18(1).
When the contract was terminated? 8th
Well,
May.
Well, this was on 8th
So
of
as per your case, there is no notice was issued to you.
notice. Now, my lord, very vital thing is, my lord, kindly see, despite opportunity.
That's why I'm telling you. Here it is
Nothing,
recorded.
nothing, my lord.
Repeated complaints have been serious
Yes.
performance activities.
My lord, with deepest respect, my lord, I am submitting, my lord, the person interest when has to be affected, he has to be, my lord, given an opportunity before affecting his interest.
Despite opportunity, proper conduct, the performance activities and work instruments have been remained unsatisfactory. Yes.
My lord, at this stage, my lord, I only pray, my lord, let report be filed.
Any notice is issued?
No notice, but my lord, kindly note page number 35, clause 18(1), termination of contract.
Yes.
Here, railways shall reserve the right to terminate the contract as a
without any notice.
punitive measure without any notice at any time, violation of any of the terms and conditions of the contract, or due to any other serious misconduct, including but not limited to violation of Railway Act 1989, commissioning of an unlawful act which is not in line with the good industry practices, or an activity of normal turpitude by the leaseholder, forfeiting full EMD or SD amount.
Correct.
Yes, my lord. Then, my humble submission. Just number 37.
Yes.
Dispute resolution and arbitration. As per the provision of the Indian Railway Act, kindly 24. In case of conflict between the standard condition of the contract and special condition of contract, issued by the Railway Board, Zonal Railway Division, any specific category of contract, if any, the provisions of the special condition of the contract shall prevail, provided such special conditions as per the provisions of the policy of the commercial earning or NFR contract awarded through e-auction. As per the provision of the Railway standard general condition of the contract, this should go to the arbitration. Go to the arbitration. So, my period is that it should go to the arbitration. Not the read petition, whether read petition is maintained or not. It is my question.
Yes.
My lord, may I reply to this?
Yes.
My lord,
So this is the only submission, 2 submissions.
Yes.
Correct? There is no further submission.
No.
Yes.
Now, my lord, with deepest respect, I am submitting alternative remedy cannot be a bar when, my lord, the fundamental right has been infringed. My lord, this is my right, my lord, to have an opportunity. Your lordship, kindly have a look, page 35.
This?
Oh, this is arbitration.
Yes.
Now, my lord, when the fundamental right has been infringed, my lord, there is no the alternative remedy.
But you accepted the terms and condition 18.1.
Prior to that, my lord, kindly see, my lord, 17.2,
Hmm.
page 35.
Hmm.
Railway shall have the right to terminate the contract agreement without any financial repercussion on either side for any reason whatsoever after serving 1 month's notice to the contractor. And the license fee I have already been paid.
Yes.
My lord, I am only submitting at this stage, my lord. There cannot be, my lord, any other prayer. I can only make a prayer, my lord. Let the railway authority, my lord, file a report stating that any opportunity and the misconduct is, my lord, the moral turpitude. Who has made this, my lord, the complaint? I have an authority, my lord, I have a right to know that.
So what has happened to this tender after cancellation?
My lord, there is no further tender.
When you filed the writ petition?
My lord, this was filed, my lord, my lord, the 8th day of June 2026.
Yes. So what do you want?
My lord, I am praying at this stage, my lord, I have submitted, my lord, that either, my lord, they, my lord, have an opportunity to me, enclosing what are the complaints made against me, who are the complainants.
So affidavit direction you want?
No, my lord, what I am praying, my lord, that let this, my lord, impugned order be set aside, and my lord, let them serve notice upon me, because there is no further tender. And they proceed in accordance with law. I shall face that.
Affidavit. I shall pray for affidavit submission.
Affidavit. What about this order?
No other instruction is there.
Finally come to 17.2.
17.2.
So this is not a contradictory.
Absolutely.
17.2 is not contradictory to 18.1.
17.2.
Yes.
They are 18.1.
Correct. Whether both are not contradictory.
Contradictory.
Contradictory. Then if the contradictory, which will prevail?
18. I depend on
Natural
18.
justice will prevail.
18.1. Yes.
Natural justice will prevail. Then if the natural justice will prevail, how you can pass the termination order all the three contracts by terminating the contract?
In a single cancellation order.
This.
No, this is fault, some fault.
This is a fashion of the authority.
My lord, in this matter, I am on behalf of the opposed party. I would like to file the AO in this matter.
I am staying the order and you file the affidavit. The petitioner has filed the present writ application challenging the order of termination of the three contracts of the petitioner dated 8th of May 2026. The respondent authorities have issued the work order, issued 3 work orders to the petitioner for operation of two-wheeler parking stand at Vishnupriya Halt Railway Station, Purva Satli Railway Station and Navadvip Dham Railway Station for a period of 3 years each. Police. All of a sudden with police. As per the case of the petitioner, that all of a sudden on 8th of May 2026, the respondent authorities by a single order has terminated the said contract by taking the recourse of clause 18.1 of the tender condition. Now, counsel for the petitioner submit that no notice has been issued to the petitioner and no opportunity of hearing has been given to the petitioner and has passed the impugned order by terminating the contract of the petitioner. Though the contract of the petitioner is valid up till 2027. 30th September 27. Learned counsel appearing for the respondent authorities has drawn the attention of this court to clause 18.1 and submit that as per the said clause, there is no necessity for giving any notice and the railway authorities have the right to terminate the contract contract without any notice. This court perused the clause 17.2 of the tender conditions, wherein it is mentioned that railways shall have the right to terminate the contract agreement without any financial repercussion on either side for any reason whatsoever after serving 1 month's notice to the contractor. The terms and conditions, the conditions 18.1 is contrary to the condition 17.2. 17. The counsel for the respondent have also raised the objection that there is an arbitration clause, but instead of taking the recourse of arbitration, petitioner has filed the present writ application. This court finds that the petitioner has filed the present writ application challenging the impugned order on the ground of violation of the natural justice, as the termination order has been issued without giving any opportunity of hearing. Accordingly, full stop. Considering the submission, this court finds that as the petitioner has filed the present writ application challenging the impugned order on the ground of violation of natural justice, as no opportunity was given to the petitioner while issuing the impugned order. Accordingly, impugned order 5th August 2020. Accordingly, the operation of the impugned order dated 8th of May 2026 is stayed for a period of 4 weeks until 11th of August 2026 or 2026, full stop. The respondents are directed to file affidavit in opposition within 3 weeks. Reply, if any, they are to be filed within a week thereafter. Release the matter on 11th August.
Deeply obliged, madam.
Madam, I am for respondent
My
enforcement
repetition.
directorate.
Yes.
My repetition, my lord. Well, this is a writ challenging.
Well, this matter,
Liquidated.
this matter, your lordship heard on the last day. We have taken the first point of maintainability because it was against a judicial order passed by the learned special court, that is CBI. Chief,
I will let me present the case.
Yes,
my lord,
and
this
then
point can be taken
my
no
learned
problem.
friend opposite was also.
Maintainability issue. The petitioner has no locus in respect of assets of a company in liquidation. He is a past director, promoter director, and at best a shareholder. So he today company is in liquidation. Order is restricted to assets of the company. I am the only person interested.
Let me, my lord, start. My lord, this is an order which has been passed by a special court under section 8(7) of the PMLA Act. My lord, I had taken your lordship on that. It's been quite a while, my lord. Through the provisions of the PMLA Act, according to me, my lord, none of the provisions falls for challenging of this order, neither the appellate or the revision. And my lord, the issue of maintainability, I would not say it's an issue of maintainability at all, but rather an issue of entertainability, whether your lordship can entertain my petition or not. Maintainable, it certainly is, because even if there's an alternate remedy, still it's maintainable if the order is illegal. And here, my lord, there's no question, no factual question I'm raising. Altogether a question, a legal question, a pure question of law as to whether the special court could have passed an order at all or not. My lord, if I may just take your lordship through the facts and then I'll come back.
What is the prayer?
My lord, for setting aside the order passed by the special court.
Special
Your lordship takes the prayer, page 16.
Page 16.
Page 16 of the writ petition.
Declaration, the order dated 10th of December passed by London Special Judge, Special Court. Where is the order?
My lord, the order is at page 47.
Who are you?
My lord, I am a director
Huh.
of this company.
Huh.
A director of this company. The company gone into liquidation. I'm a
Correct.
well director.
Correct.
No, that I will come to that also, my lord. I'm one of the defendants in the complaint where, my lord, this order has been passed.
Correct.
Now, my lord, yes, my lord. My lord, like the order portion, my lord, if your lordship takes paragraph 8
Of
this order,
yes,
of
I've
this order,
gone through.
the special PP submitted that the ED has no objection in principle to the consideration of the request under 8788, subject to submission of standard and taking prescribed under IBBI circular dated 4th November 2025. He further submitted that upon full satisfaction of the bank outstanding, claims in respect of the attached property, surplus amount, if any, realized from such auction shall be deposited before this court or with the ED.
Correct.
Now then, on perusing the documents annexed to the said petition, I find that the petitioner, Anup Kumar Singh, was appointed as the liquidator of the A1 company corporate debtor, vide order dated 14 September 2018 in so-and-so Kolkata bench NCLT. The ED has seized the assets and properties of the A1 company in connection with this case. In my considered opinion, the liquidator should be permitted to take possession of the said assets and properties of A1 company. Further, to prevent its deterioration, the liquidator should be permitted to auction the same. The delay in auction of the properties will significantly obstruct the recovery of public funds. The learned public prosecutor appearing for the ED has also raised no objection in permitting the liquidator to take possession of the seized properties. The liquidator has also submitted the undertaking under the prescribed IBBI circular. Accordingly, petition dated 4th March 2025 filed by the liquidator is allowed. The liquidator Anup Singh is permitted to carry out requisite valuation of the said properties to auction the same in following due process of law. Now, my lord, this order has been passed under section 8(7) of the Act. My lord, will kindly take the application where this order has been passed. The application, your lordship will find at page 34. 34, it starts. Will kindly take, my lord, page 37, where the cost title is there. And your lordship will find, my lord, in the legend of the application, the title, it's mentioned that this is an application under 8(7) of the PMLA Act. So kindly takes 8(7). Well, there's a PMLA Act, if your lordship.
Hey, PMLA Act होता है?
I have a copy.
बुक सब लाके रखते जाता है कहाँ? Yes, it's बोला ना अल्फाबेटिक रखो, अल्फाबेटिक रखिए. P का है. Yes.
My lord, kindly take section 8. Before, my lord, your lordship takes 8(7). Starting from section 8, 8(1). My lord, let me take your lordship through 8(1), 8(3), and then 8(7). On a receipt of a complaint under subsection 5 of section 5, or on applications made under section 4 of section 17, or section 10 of subsection 10 of section 18, if the adjudicating authority has reason to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the sources of his income, earning, and assets out of which or by means of which he has acquired the property attached to under subsection 1 of section 5, seized or frozen under section 17 or 18, the evidence of which he relies and other relevant information particulars, and to show cause why or on all such properties should not be declared to be properties involved in money laundering and confiscated by the government. And I'm not going through the proviso. Kindly takes 2. The adjudicating authority shall, after considering with the reply A, B, C, then my lords B, by an order, record a finding whether all or any of the properties referred to in the notice under subsection 1 are involved in money laundering. Now under subsection 3, where the adjudicating authority decides under subsection 2 that any property is involved in money laundering, we shall, by an order in writing, confirm the attachment of the property made under subsection 1 of section 5 or retention of the property
or records seized or frozen under section 17, 18, and a finding to that effect, whereupon such attachment, retention, or freezing of freezing of the seized or frozen property or record shall A and B, my lord. Now, my lord, under 8.3 applications were filed. My lord, kindly takes the orders which were passed under 8.3 initially.
By the adjudicating authority?
Yes, my lord.
Where is that?
Let's start with page 19. This was the first application, my lord, where your lordship, your lordship will come to page 19. Kindly sees, my lord, it has been filed by the deputy director, Mohsina Tabassum, complainant. Number 1 is Sri Ganesh Jewelry, the company, defendant number 1. Kindly see number 2, that's Nilesh Parekh, chairman, that's me. And now, my lord, if your lordship comes to the ordering portion, my lord, at page 25, paragraph 11, the provisional attachment order is not confirmed and complaint is dismissed. So there was no order which was passed. Paragraph 11. The provisional, page 25. This is an order dated 9th October 2019 by the adjudicating authority.
Yes.
The provisional attachment order is not confirmed and complaint is dismissed. On a thorough perusal of the PAO, complainant relied upon documents, the investigations conducted by ED, and the statements on record under section 50 of the PMLA, and on careful consideration of arguments advanced on behalf of the complainant and the defendant undersigned, comes to a prima facie conclusion that the defendants have not committed scheduled offense, generated proceeds of crime, and laundered them. No doubt the properties attached are not proceeds of crime or value thereof and are not involved in money laundering. Undersigned therefore orders non-confirmation of the provisional attachment order. This order shall continue during the pendency of proceeding related to any offense under the Act before court or under the corresponding law for any other country before the competent court of criminal jurisdiction outside India, as the case may be, and become final after order of confiscation is passed under A5, subsection 5 or 7 of section 8 or under section 58B, 2A or section 60. Appeal against the order lies before the Honorable Appellate Tribunal, PMLA, under section 26. Appeal may be filed within 45 days. Now, my lord, kindly, they filed an appeal. Kindly takes page 30. So, no order passed under 8.3 by the adjudicating authority. Appeal filed. Kindly now takes appeal. My lord, I must say, my lord, there was a rectification order, page 27. I made a mistake. Your lordship kindly takes page 27 first. There's an order of rectification by the adjudicating authority, 20th January 2020. Your lordship takes page 28, last paragraph. Mr. Sri Ganesh Jewelry House Limited is the company and it's under liquidation process. So status quo order with respect to properties of Sri Ganesh is not passed. In respect of other properties concerning other respondent parties, directed to maintain status quo till next date of hearing. So far as Sri Ganesh is concerned, no order of status quo. So far as other defendants are concerned, including me, order of status quo passed. This is by the adjudicating. Now, my lord, kindly takes the appeal, page 30. No, 32 actually. 32. The counsel for the respondent number 1 and 21 prays for time to file reply.
Yes.
The counsel for the appellant prays for status quo order in reference to properties of respondent number 1. It is submitted that the earlier this tribunal passed an order of 20th January 2020 to direct status quo in regards to the properties of the respondents, leaving the respondent number 1 who was not present. Then, if your lordship takes the last paragraph, the prayer is opposed by the respondent number 1 and submit that let the reply to the stay application and appeal be filed by them. He prays and granted 8 weeks time for apposite as prayed. Let appeal be listed after 8 weeks. However, during the intervening period, there would be status quo with regard to properties of respondent number 1. interim order would remain subject to further arguments by the counsel for the respondent number 1 on reply. The status quo in reference to properties of other respondents exits, thus no further order is required. So, my lord, the order which is passed by the appellate authority is, my lord, there would be status quo with regard to properties of the respondent number 1. This is on 20th September 2023. This order, my lord, is now, my lord, passed under 8.3, and there's an appeal pending. The pendency of appeal is there. Now, my lord, kindly takes the law first, and then I'll come back. Supreme Court 2026. This point, my lord, came up whether while pendency of appeal is there, now there is no finality because appeal by the appellate authority will finally decide whether the attachment order should be there or not be there.
One sentence. 2024 October Supreme Court conclusively decides order of criminal court cannot be made subject matter of writ petition under Article 220.
And I will also relying on certain judgments on the maintainability.
Yes,
I'll come back. I'll come to that. I'll satisfy.
No, he's on merits. He's on merits.
I am. My lord, there are various judges. I mean, kindly give me a copy.
Yes, I'm giving you
one copy.
Tony
let me finish my arguments, then these points can be taken.
I am relying on that.
Orders under 226 not possible. And then, my lord, council said very well under 227 and 482 consider that, my lord, the finding is at paragraph 15 that can't be done on a writ petition.
Nita Singh, in my compilation.
So, my lord,
Nita Singh, I am also applying. But paragraph 13 to 19.
Well, let me place my facts, then these can
but
be taken.
it is not maintained.
Maintainability is not an issue, my lord. I will place other judges. I think Pepsi Food.
No, the recent
kindly
judgment-
considers.
Because special judge has passed an order.
Special court.
Yes, special court has passed. Special judge has passed an order. This is a criminal matter. This is a criminal order.
Yes, my lord.
Criminal order. You have a two remedy. Either you go for the revision against the said order, or you go to the 482. How the
If I could have filed a 482, I could have filed a 226 also,
no,
my lord.
226 only with regard to the total proceeding. Quashing of the total proceeding 482.
Yes, ma'am.
And 226 make lie. And that also there is restriction.
But I have given a compilation of judgments.
There are some judgments there are judgments even after that saying, my lord, that even, my lord, 226 with the scope of 482 and 226, my lord.
That's why 226, 482, I agree.
Yes,
but that is if you are challenging the entire proceeding and quashing of the proceeding, it will come as a 482. Not a single order under 482. Single order either 397, 401.
My lord, I will be very honest here, my lord. I want a remedy. If I'm left remediless, I'll go under 401.
You go to the criminal
My
court.
lord, your lordship will give me that liberty to go before criminal court, then I have no problem.
Right.
My lord, no, my lord. Otherwise, my lord, here a point of maintainability is taken. There again a point of maintainability
Then
be taken.
his lordship
My
will
lord,
consider
I
that.
need 226. I feel I can justify. I can possibly, my lord, be able to satisfy your lordship that maintainability should not be an issue. Issue is regarding entertainability. Whether your lordship should entertain or not. Whether, my lord, I'll go before a 401 court, again the same point will be urged. My lord, I don't want to suffer that. It's no question of forum shopping. I want a remedy. I cannot be left remediless. If your lordship, well, and they also agree that, okay, 401, I have a remedy, which your lordship had said. I don't mind going there. But again, I'll go there and again a point will be raised. No, you do not have a remedy under 401. The petition can't be held maintainable. Then I won't be able to come back here also after that. My entire issue, my lord, legally, my lord, I can show that the order which has been passed is not sustainable. Pure question of law. The order passed by the special court is not sustainable. Not on facts, but on law. So, my lord,
the order passed by the special judge, it's a special judge under the criminal, as a criminal court, not a quasi-judicial. If it is a quasi-judicial, and the state is a party to the writ petition is maintainable. But if it is a court under the code and passed by the special judge under the CRPC, under the court, then
I agree with you. I do not want to go through an unnecessary exercise. I'm ready with the facts. My lord, my only issue is, my lord, I should not be held remedy-less. I'll go before 401 and then again a point of
You withdraw,
maintainability
you
will be
withdraw that
taken.
and I will give the take everybody stuff is in accordance with law.
No, my lord, your
You
lordship,
want to argue the
your
matter,
lordship
then,
is, I am
then
ready
we
to
hear
argue.
no problem. You persons know I am
I
ready
know,
to
my
hear
lord.
the matter, then
But only thing is, I
we
should not
don't
be.
know what would be the consequences.
No, no, only thing is, I feel, my lord, I strongly feel, my lord,
Dismissed. 100% I know. I tell them this will get dismissed.
Section 43 defines special court. Section 43.
I will show. I'll go through the provisions, each one of them. There's no problem. My lord, I will be able to show maintainability. I agree, my lord. Whether your lordship will entertain or not, there is an issue. But my issue is, my lord, if I go before some other court under 401, as it has fallen from your lordship, they'll again take the point of maintainability.
No. How when they kindly come to the 43 special court defined?
Yes, my lord.
Correct. Then there is an
There after 47, 43.
47. Yes. I read that.
I agree, my lord. There are chapter 20 and chapter
47, appeal and revision.
Yes, my lord.
The court may
Chapter
exercise
29 and
appeal
chapter 30
conferred
of the
under
CRPC.
chapter 29 and 30.
Chapter 29 is appeal. I don't come under 29.
Then 30.
30 at most 401. But they might, if they take a point of 401, if a lordship holds that my remedy is under 401, then I'll go before 401.
So why are you wasting the time? You go directly take and
My lord, since
go.
it's not that I do not have a remedy under 226. 226, your whether
See,
it's
I am not forcing you. If
No,
you
ma'am.
want to argue, I will hear you.
My lord,
You don't
my
understand.
argument is, in a nutshell, my lord, I'll show judgments also. Under Article 226,
If you want
I
to
have
argue
a
the
remedy.
matter, then you
No, my
have-
lord, my lord, I do not want to. I don't want to go through a futile exercise.
That's
I will
right,
tell your
that's
lordship, my lord, my argument which I've thought about
And it
is,
is
my
my
lord, that
bad habit.
At least 6 judgments I have cited, including that need to see.
my lord, under Article 226, my writ petition is
And
maintainable.
Mr. Chaudhary is a victim of my habit.
Mr. Chaudhary is the RP. He is going to auction.
And he is the creator of this.
He is the creator. It was his petition.
Every
the
time he is the
order-
creator. Everywhere he is the creator.
Well, the order cannot
Everywhere he is
subsist. I am 100% sure the order which has been passed by the special court cannot subsist. Issue is where do I go? Now, my lord, 226, my remedy is there. It's only issue of entertainability, not maintainability. Maintainable.
Because adjudicating authority passing order, this court can entertain quasi judicial. But the criminal court under the code.
Well, there are orders even. Well, the Supreme Court, my lord, has passed judgments even now. Even from a criminal court order passed, my lord, 226 orders have been passed. But exceptionally high case has to be made out. I agree with that, my lord. I'm not.
Paragraph 5 of that judgment, I think now it is sealed shut.
Need to see. Need to see.
Although
Article 19.
Radhesham dealt with
Radhesham dealt with the
orders
subsequent.
by civil courts.
Even initially, what the court, the writ court, they are converting it. Then the Supreme
Yes.
restricted.
The nomenclature is
No, that's why. Earlier it was the writ court means it is the court used to convert the matter. Now the Supreme Court restricted. Now you cannot do by saying
That judgment,
The
if you mention,
nomenclature of 226,
takes para
227 or
13, para
222.
19 of that judgment.
Sir,
Need
may
to
I
see.
see that judgment also? Which
Yeah,
I-
need to see.
Go through.
Need to see.
My lord,
Go through.
I'll go through, my lord, but I'll be very honest. I do not want to go through a futile exercise. Maintainability issue, my lord, I think I'll be able to satisfy. Entertainability, I agree, my lord. Whether your lordship should entertain or not, I agree. There is possibly your lordship may feel not. But one of the issues, if I hear it, on the issue of entertainability, your lordship does not entertain. And then I go, my lord, I cannot be left remediless. That's my only thing. I
Not
go before
remediless.
401,
Yes.
and then again a point of maintainability will be raised. there.
Why?
Lordship will kindly hold that. We give me liberty to move on.
It cannot be, my lord, held to be maintainable in this procedure.
My lord, your lordship has to hold what is my remedy.
He cannot even
So the entire issue is, well, the entire issue, there is an alternative remedy. Your lordship will hold what is the alternative remedy available to me. That is all I'm saying. My lord, only way, my lord, your lordship will hold that this court, the remedy of 226 will not be entertained is if there is an alternative remedy available. Your lordship will hold what is the alternative remedy so that I know where I can go. Well, that is not being said. Issue is whether there is an alternative remedy, only then the writ petition is not maintainable.
We are saying you have judicial remedy. We are not saying alternative remedy. Our point is very clear.
Kindly say judicial remedy under which provision?
We are not here to advise your client.
Then how do they say it is not maintainable?
We are showing
They have to
judgment.
say something.
We are showing.
Only when
provision
you
of
say
law.
there is alternative remedy, doesn't make a difference. They have to
We
say
are
what is the alternative remedy.
We are saying it is not maintainable because of section 43, 47, read we chapter 30 of CRPC.
I can come back at 2 o'clock if your lordship wishes.
2 o'clock other matter is there.
Then I'll come back tomorrow, my lord.
Tomorrow, not today.
Tomorrow.
You go through the judgment.
I'll come back tomorrow, my lord.
Go through the judgment.
Only thing, my lord, what is the remedy, alternative remedy available to me? That has to be mentioned by them. Only then your lordship. will know.
Minister for the petitioner has argued the matter at length and praised for
Maybe Monday, because
My lord,
we are both not there tomorrow.
Monday.
let the matter
Monday.
appear on 13th. Yes, I have given.
I'll come at 3 o'clock.
Yes, come.
I'm obliged, my lord, for a patient hearing of that.
Malad has kept it on Monday.
Monday,
No, সময় না এমনি লিস্টে রাখবে মানে fairly at the top, I believe.
Within 5 minutes. Sir.
Deep revelation.
My lord, may I have the urgency mentioning, my lord?
This is not the time to mention.
Yeah, my lord, but very urgency, my lord.
What is the urgency?
Regarding SIR, my lord.
SIR matter, there is no urgency. Go to the appellate tribunal.
Admit in the school.
Ah.
Her baby is admit not to school, my lord. For voter.
Which school? Which class?
Admit
Which?
for nursery. My lord, very good urgency, my lord.
What has happened to the public interest litigation? The issue is pending in the public interest litigation. What has happened?
Your lordship, may I mention?
Come tomorrow morning, we'll see to
My lord.
Okay.
My lord, would you kindly, your lordship, item 11?
What the court will do? Just matter.
Your lordship, on original side matter, your lordship is a.
Original set come at 3.
My lord, that is what I was here for, my lord. May I just indicate, Mr. Joyanto Mitra called me up also. That matter which is fixed at 3 p.m. I don't know, there is some jinx, my lord. I don't know, somehow. My lord, lordship is fixing it, but today again from 2 p.m. they have passed a resolution not to, my lord, appear. So, my lord, he is there online. He has told me, please go and mention. And, my lord, that is why, my lord, if your lordship takes it up, we'll do the matter. Otherwise, lordship fixes, my lord. Lordship knows, my lord, lordship is fixing, but it is all due to the, my lord, this side. I cannot complain. So, my lord, kindly, my lord, in that case, should we come back at 3 p.m. if your lordship is there? Otherwise, my lord.
I don't know whether there is any resolution.
There is, my lord, there is.
Communicated here.
So it will be. In the due course, it would be. So should we come back at 3 p.m. or lordship will fix a date, my lord? I'll inform him, my lord.
If on the basis of resolution, if nobody is appearing, then I will go.
No, my lord, today the resolution is little tricky. I believe it is said not to participate. That is little
Nobody
tricky, my lord. So
if it is not taken, then date will be.
no, my lord, this matter, lordship remembers, this is that, my lord, matter with regard to the senior gown. It has been fixed after a lot of, my lord, consultation with my lord, Mr. Mitra and myself said any day which lordship is, my lord, free. So, my lord, lordship had fixed it long back before the vacations on 9th of July at 3 p.m. As I say, my lord, there is some jinx, my lord. I can't say more than that. I cannot, my lord, say something, my lord, more to what my lord has, my lord, cooperated with both of us. And I'm grateful to Mr. Mitro. My lord, he is one man who called me up now and, my lord, said that please go and say to the court I'm there to
And
fix
that's
up
correct.
any
That's
day.
correct. Then date is to be fixed.
So
If
kindly fix a date, I'll inform him
but
then.
my other side is not here.
Should I come back at 3 only for this purpose? May I come back at 3?
Come at
Great.
because the 3 I have to sit because the interim order is when.
Very well, man. I'll come for this only, man. I'll take 2 minutes of my lord. Great.
Your lordship, should I mention at 3 p.m.?
Come at 3. For extension, why you mentioning?
For inclusion in the list. Today I have filed. There's
Come at 3. My officers are not here. Yes, call the list.
My lord, my learned friend had just said about the resolution, my lord. The bar, my lord, not to participate, my lord. And now, my lord, it's up to my lord.
Any interim order? No.
No, my lord, no interim order, my lord. My lord, the urgency is that, my lord, there is a continue, my lord, there is the termination is continuing, my lord. Again, they will tell
Termination of?
termination of the contract, my lord, and my lord, my lord, and continuing, my lord.
They are only challenging the blacklisting,
No, no,
temporary
it is not a-
blacklisting,
it is
and the
also-
blacklisting was for my
It
lord,
is
for a
also
very
the
short
temporary,
period.
already.
Temporary period is not over.
My lord, that is already over.
It is over, but it is to be heard on merit, my lord.
My learned
And my lord, and the termination is also, my lord, in the if it is not heard, my lord, my prejudice, the petitioner is suffering prejudice, and my lord, if a short date is
Tomorrow your resolution is there.
yes, my lord. If a fix a date, my lord, short date,
Fix
my
the
lord.
date, then it will go to September.
My lord, short date, my lord. Today I am ready, my lord, to hear my lord.
Take diary from my court office. If you find any short date, you
My lord,
tell me, I will
it is very much unfortunate, my lord, for the petitioner, my lord. It will be highly obliged, my lord. Any day, my lord, at your pleasure, my lord.
That's I'm telling you. Give the diary. You find.
No, my lord, I will not do it.
My court officer. How I
my
am
lord,
seeing the
my lord,
diary.
any day, my lord.
What date hai? 9 September.
My lord, 9.
Before that, there will be no date. If you want to fix the matter, otherwise, any date
My
can
lord,
be
fix it, my lord. Fix it, my lord. Because my lord, any August, my lord, it will be,
August
my lord, we will
already
be very much prejudiced, my lord. Any big prejudice, my lord.
not
My lord, the termination period will go again. They will again plea for infractuous, my lord. The termination, termination period will infraction.
That is already recorded. Though the 45 days has been over.
That is my lord blacklisted, my lord.
Married.
But my lord, the termination also, my lord, there is a termination. My contract period is on, my lord, and in between that only they have terminated.
Been awarded.
No, my lord, nothing has been. But if it not fixed as short date, my lord, then petitioner will suffer. Any, my lord, any date, my lord.
और क्या डेट क्या कोई है? I don't think any date will be there. कब है? हाँ? Though the matter is specially fixed today as 2 p.m., but due to the bar resolution, the matter could not be taken up for hearing. According to case adjourned, let the matter appear on 13th August at 12 noon.
Extremely grateful, man.
Extremely grateful.
Next.
Millard, in item number 11, I appear on behalf of Canara Bank, Millard, respondent number 3.
Yes.
My lord, I appear for respondent number 2, HDFC Bank, my lord.
For the petitioner, nobody. Let the matter appear on 6th of August 2026 under the same matter.
Grateful,
Much
madam.
obliged.
Lordship, learned advocate Saikranian Ganguly is appearing in this matter and he is on his legs. I'm requesting for a short passover.
Who is for the petitioner?
In person.
You are appearing in person. What is the matter?
The Lok Adalat has given an order which is not correct because they are.
Lok Adalat given an order, it is not correct.
Yes.
So you filed a writ petition.
Yes, I have.
Where is the order of the Lok Adalat?
I'm giving. Is there in page number? Give me a second. This one isn't annexure number P1.
Which page? Page?
It's this.
Yeah.
Problem is that there no parties has put their signature as per the before passing any local order. First, the petitioner, the person who complained, and should sign. Then the who is a member of the local adalat and the president should sign. In that case, my signature is nowhere there. So this local adalat order is not maintainable.
You file a review application before the Lok Adalat. Why you are filing?
Because this is not a permanent.
Lok Adalat order cannot challenge. You can't challenge unless and until there is an arbitrary. You can't challenge the Lok Adalat order in the writ petition or civil suit or any proceedings.
So
Lok Adalat, what is the Lok Adalat order is passed on consent.
No, I have not signed the consent. Problem is that when I pass.
I don't know. You go and file a review application before the Lok Adalat.
Because this Lok Adalat is not a permanent one. This is temporary one.
Not temporary. Not whenever the National Lok Adalat sits, it publishes. Every month there is a National Lok Adalat, or every 3 months. I might be. I may be wrong. So you go through the paper. There, I think when next month or next. It was there. Now I think next month will be there. Every fourth Saturday or something is there. You check and file a review application, not a writ application.
Okay.
Withdraw. You want to withdraw?
I want because problem is that Article 226. I
am giving the liberty to take appropriate step before the.
Okay.
The petitioner has filed the present writ application challenging the order passed by the National Lok Adalat dated 13th September 2025 in consumers complaint number DC/315/CC/148/2023 within bracket Shekhar Pal versus ICICI Bank Limited. Full stop. Land counsel for the petitioner is appearing in person and submit that that the Lok Adalat has passed the order without taking the signature of any of the party, and as such the order is bad. Full stop. The only grievance of the petitioner that the Lok Adalat has passed the order without taking the consent and without any signature appearing in the impugn order. In view of the above, the full stop. In view of the above, the
Can I get 1 minute to just?
For what?
Can I? This is the order passed by the. This is the order. Excuse me.
Yes. What?
Order passed by the Karnataka High Court, who clearly classified that if there is no signature, the order can be squashed by the High
Okay,
Court.
you go and file review application. Because the Lok Adalat who have passed an order, that go there. क्या बोला? About the petition, the writ petition disposed of, giving liberty to the petitioner to file a review application before the Lok Adalat, before the National Lok Adalat. क्या बोला? Review application for reviewing the order dated September 2025 before the National Lok Adalat.
Lordship, my learned senior is online for this matter.
My lord has already disposed of the matter, my lord.
Yes. Next.
My lord, I can even, my lord. Item 11.
You want to argue? Argue the matter? Yes, give the 11. Call 11. Change.
How আটকে গেছে? সবাই আটকে গেছে। Lordship, the service is concerned, Lordship. I will file the affidavit of service.
Where is the affidavit of service?
Affidavit of service giving all junior, all everything, Lordship.
Huh?
Affidavit of service with my junior. I, Lordship came on. They're coming, Lordship.
So what is the case?
Case is, Lordship, the bank account arbitrarily, Lordship, the seized by the respondents' banks. Lordship, without complying with the provisions.
So presence of the bank is required.
Bank, Lordship, all the service.
But today there is a resolution of the bar. You don't know.
I know, if you.
My lord, I am appearing for the respondent number 2 SDFC Bank, but the learned advocate who was representing.
Appearing.
My lord, SDFC Bank, my lord, but the learned advocate who was representing other respondent, Canada Bank, he might have left, my lord. Since I have another matter, I was.
Both the bank account has been seized. Please.
Both banks.
So, but Canada Bank is not there.
My lord, what I am submitting, my lord, your lordship, can you fix his matter on any other date, my lord? I will file my report, my lord, to that extent. Yes, my lord.
Since appearing for the respondent HDFC Bank, full stop. This court find that a report is required to be filed by the bank with regard to the account of the petitioner. Accordingly, the respondent number 2 and 3 are directed.
No, my lord, I am for the 2 only, my lord.
Respondent number 2 and 3 are directed to file the report disclosing the status of the account of the petitioner, how the account has been seized, and what is the disputed amount with respect of the account of the petitioner. Let the report be filed within 10 days after serving the copy to London Consul for the petitioner. The petitioner's liberty to take exception to the report, if any, within a week thereafter. Let the matter appear on on 30th July.
Lordship, not 30th, Lordship, 14. 13 July, Lordship, the specially fixed matter.
30 July.
Already I have
record the petition director to communicate this order to the respondents for their compliance.
Grateful.
I have got the order.
Grateful, my lord.
Yes, next.
My lord, in 13, I am appearing for RBI.
So appearing for the RBI. None appears for the petitioner. Let the matter appear on 6th August.
14, my lord, I appear on behalf of the petitioner, my lord.
Yes.
It's a matter pertaining to the matter of legal guardian appointment.
Yes.
Kindly takes 28th April order, my lord.
Yes. Who is for the respondent?
State is the respondent, my lord. There is the resolution, my lord. There is a.
Yes.
There
There's a resolution.
My lord, date may be fixed.
None appears on behalf of the respondent. Let the matter appear on 7th August.
Within, my lord, within 10 matters.
Next.
Within 10 matters, my lord. Otherwise, matter.
Next.
My lord, my lord. That-
For the petitioner, your lordship, this is that matter, Lord. Refusal to renew the passport of the minor child.
Your Lordship, I am appearing for the Passport Authority, Your Lordship, because of the resolution. I was praying only for not today only, Your Lordship.
I am not standing in the way, just that, my lord, my prayer, my lord, if the matter retains its position, my lord, in the list. Because I am ready with the matter, I can do the matter.
I am led by Mr. Kumar Jyoti Tiwari.
That is the problem. Now, tomorrow, how this matter can be accommodated tomorrow? My diary is packed till the September. I
Your
can't.
Lordship, before the lunch, I was there, Your Lordship, till 1:20.
It is your responsibility. Let the matter appear on 7th August.
My lord, let me start, my lord, let me do the matter, your lordship.
If you want to do, I will pass a prepared order. What can we do?
Let me do the matter, your lordship.
Yes.
My lord will find, my lord.
Your Lordship, we would like to file an opposition to the writ petition, Your Lordship.
You are not appearing in the matter. Last occasion also not appeared.
Your Lordship, we had appeared. The petitioner on the last occasion had not appeared. We have been appearing with the learned ASG was appearing, and Mr. Kumar Jyoti Tiwari was appearing, Your Lordship. And Your Lordship, we were representing. We had also filed the. It had fallen from Your Lordship to file the passport manual. We had also supplied the copy. I have instructions that if we could file the short affidavit, Your Lordship, if Your Lordship could allow us to file the same.
On the similar issue, my lord, there is a judgment of Delhi High Court, which I would like to rely upon, your lordship.
But they are not. What can be done? Your draft resolution. Not today.
My lord, tomorrow it will appear now, my lord.
I don't know. Yes, next.
My lord, I am here. I will serve a fresh copy to the state, my lord. Kindly, my lord, keep it a short date, my lord. I will serve a fresh copy.
As none appears on behalf of the state, let the matter appear on 7th August.
My lord, kindly consider, my lord.
Next.
My lord.
Next.
Told by the clerk of the learned senior, Mr. Ashok Banerjee, my lord. He is appearing for the petitioner, not today. Appearing
not today. Next.
My lord, this is my petition. My lord, challenging my lord, the classification of my accounts as fraud. Now, my lord, my account has neither been red flagged nor my lord, it has been, my lord, kindly comes to my lord, the
Financial auditor.
Who is for the bank?
But I appear for the bank.
You are appearing for
circular my lord, for my lord, declaring a my lord, account as
Where
fraud.
is the impugn order?
My lord, kindly comes to page my lord, 163. It starts at page 163.
This is the circular.
This is a circular, yes. And the entire case is on circular only. Now, my lord, kindly comes to page 165. Clause 2.1.
Yes.
Governance structure in banks for fraud risk management.
Yes.
Now, my lord, kindly see 2.1.1.1 issuance of a detailed show cause notice to the persons, entities, and his promoters, whole-time executive directors against whom allegation of fraud is being examined. The SCN shall provide complete details of transactions such and such and such. Now, my lord, 2.1.2. A reasonable time, not less than 21 days, shall be provided to the persons, entities on whom the SCN was served to respond to the said SCN. Now, my lord, my first point, my lord, kindly comes to my lord, the show cause notice issued by the bank at page 99. I will go millet side by side. 99. This is the show cause notice. Now millet kindly takes 103. The first violation is
99.
99. It starts at page 103.
Yes.
Now millet kindly see para 3.
Yes.
The mandate says not less than 21 days.
Correct.
Kindly see para 3.
You're
If
advised to
kindly leave apart millet first 4 lines. Then millet if your reply is not received by us within 15 days. So millet this is the first violation. Millet I have given reply to this. Now millet kindly turns the page at page 169, chapter 4. 4.1. 4.1.
Yes.
In case of a credit facility or loan account classified as red flagged account, bank shall use an external audit or an internal audit as per their board approved policy for further investigation in such accounts. Millet, my account has never been red flagged. Now, Millet, without red flagging the account, Millet, they have carried out an audit. Millet, the first criteria to carry out an audit is Millet, the account has to be red flagged. Now, Millet, what is red flagged? That my lord will find at page 167. Para 3. Chapter 3, para 3.
Yes.
3.1.1.
Yes.
Bank shall have a framework of early warning signals and red flagging of accounts under the overall fraud risk management policy approved by the board. A red flagged account is one where suspicion of fraudulent activity is thrown up by the presence of one or more EWS indicators alerting, triggering deeper investigation from potential fraud angle and initiating preventive measures by bank. The Risk Management Committee of the board shall oversee the effectiveness of the framework of the EWS and RFA. The senior management shall be responsible for the implementation of a robust framework for EWS and RFA within the bank. Then let EWS indicators identify the monitoring credit facilities, loan account, and other banking transactions shall be approved by RMCB. Approved turnaround time preferred not only more than 30 days for examining EWS alert. Triggering shall be prescribed by. This is the procedure. So Millet, my contention is that Millet, we are not Millet aware that Millet, my bank account has been red flag, quote unquote red flag. Now Millet, coming back to the Millet audit. Now Millet, to label me as a fraud account, Millet, the audit Millet they have carried out. Now Millet kindly comes to the audit report. Now the audit report Milo will find at 106.
Yes.
Now Millet, for creating an audit report, Millet carrying out an audit process, Millet, my assistance is required. The auditor has to visit my office. Now Millet, kindly see 113. 113. Audit methodology, discussions, interviews. The audit team has not yet visited the Bank of India club.
Where from your reading?
113. Starters page 106 at page 113. Part of the audit report.
Yes.
Now Millet, kindly see the audit team, para 1.3. The audit team has not yet visited the Bank of India club side branch. However, they obtained the financial statements, bank statements, and state sanction letter from the branch and clarify queries to the extent possible over call and via email. We have also communicated with the officials of the company. Audit team has made visit to the company's registered office in West Bengal and found the office is closed because of Durga Puja. So Millet, he could not Millet get any document from me. Millet, that's my Millet answer, reply. That Millet, if you visit somebody in Bengal during Durga Puja, naturally you'll find the office closed. Now Millet, kindly see, para C.
So you have given the reply. In the reply,
I have taken all these points.
You in the reply you could have been.
I have taken this. Yes, I have taken all these points. Despite that, Millet, my account has been declared as fraud. That's my issue before your lordship today. Now kindly see C. B is the documents and information sought. Naturally, he will not find because Milad, he has visited my office during Durga Puja. Now, kindly see C. Review and receipt of documents. As per the scope of audit defined by the Bank of India Inspection Department, the account of the company has turned NP on such and such. We have asked Bank of India to provide us financials starting from such and such to such and such. Forensic audit is planned to be conducted for the period starting from 1st of April 2013 till 31st March 2025. Milad, my account, Milad, I have not filed the Milad balance sheet as on 31st March 2025. It has been filed till 2024. Now, however, we are provided with the financials from such and naturally till 2024 because by that time I had not filed. We have carried out a review of the information provided by the bank. Now, let kindly see 1.4 of that page, limitations of our audit. Last paragraph. We have received the documents and data such as CC account statements, audited financial sanction letter from BOI. We have relied on the documents furnished by us by BOI, and our observation are primarily based on our review of such information. So, Milad, entirely on the documents provided by BOI. Now, Milad, kindly turn the page 115, para 9. We have received documents and information in respect of the bank transaction with Bank of India only. So, Milad, in Durga Puja, I am closed. He has visited my office during Saptami, Ashtami, Navami. He found my office closed. So, Milad, I could not provide anything. I have taken these points in my reply. Despite that, Milad, my account has been termed as Milad, quote unquote, Milad, fraud. Without Milad, kindly see no visit. Kindly see the immediate paragraph. No visit and interaction with the directors and any officers of the company is done. So, Milad, they admit. Well, without my assistance, well, I'll show recent 2 judgments which Milad now guiding this field of Milad of the Honorable Supreme Court, 2 latest judgments, Milad. And Milad, kindly see the conclusion of Milad the audit, page 140. 140. Yes. Kindly see, there are multiple channels indicating that funds were likely diverted from the company. So, Milad, inconclusive words. Likely diverted from the company for the benefit of its directors and related entities. This is evidenced by a sudden shift of the high-risk unsecured loans from related parties and nearly 9-old fashion explosion in suspicious advantage to suppliers. Milad, I could have provided the documents. Now, Milad, see, kindly leave 1 bullet down. Then, Milad, the 3rd bullet. We have seen severe fluctuation in the trade receivables, creditors, inventories, but as we have not provided the list of receivable payable, thus it is not possible as to report a genuine. Naturally, receivables are with me. You have to contact me. Now, kindly see, Milad, the order. My lord, will see my show cause reply. Page 143. (143) is my reply. Milad, all the points are being taken. Now, Milad, kindly see the order. 151. Kindly see the ordering portion, Milad.
Yes.
Milad, order, there are several scribblings, Milad, I about. No. Milad, kindly see, Milad, at page 158. An interest study was done on the order, Milad.
Order has been tampered with.
158. In the light of the above facts, after providing above opportunity to the notices to make their submissions, the bank has decided to classify the account as fraud. Milad, no hearing was given, but Milad, kindly see.
No hearing was given?
No hearing was, only documents were sought for.
SCN, so-called notice?
Yes, so-called, right, Milad, I am coming to that. Now, Milad, there are 2 judgments on this. Milad is aware of it. Milad, kindly see the, Milad, the master data at page 96 once again. Master direction. Kindly see at page 165. 165. Kindly see the note below. Serial number 5 at page 165. It's entirely on a judgment passed by the Honorable Supreme Court in Rajesh
Agarwal matter. Now, let's kindly see the Rajesh Agarwal judgment. Copy it. It's 2023 6 SCC page 1. Copy Millet Rajesh Agarwal said Millet kindly comes to para 75. And kindly note this is a 2 judges bench. Why I am mentioning Millet, I'll later on Millet explain to your lordship Millet. Kindly see para 75. Millet, on this Millet, this circular has been issued on this judgment. As mentioned above, clause 8.9.6 of the master directions on fraud contemplate that procedure for the classification of an account as fraud has to be completed within 6 months. The procedure adopted under the master directions on fraud provides enough time to the banks to deliberate before classifying an account as fraud. During this interval, the bank can serve a notice to the borrowers and give them an opportunity to submit the reply and representation regarding the findings of the forensic audit report. Given the wide time frames contemplated under the master directions on fraud, as well as the nature of the procedure adopted, it is reasonably practicable for the bank to provide an adequate opportunity of hearing to the borrowers before classifying their account as fraud. Now, 76. The exclusion contemplated in the decision of Tulsiram Patel would not be applicable because giving an opportunity of a hearing to the borrowers will not obstruct taking a prompt action under the master direction, because a case was made out that giving a personal hearing will take a long time.
That is clarified by the recent judgment.
Yes, but to that, I'll also rely on that. Kindly takes page para 80. Man, it seems Milad has seen several times.
Yes.
Para 80, audio alternate pattern has several then it goes on. Now kindly see, kindly notes paragraph 81, then 85. 85.
Yes.
Fairness in action requires a procedure which permit impartment of fundamental rights ought to be just, fair and reasonable. The fairness, the principles of natural justice have a universal application and constitute an important facet of procedural propriety envisaged in Article 14. The rule of audio alternate party recognized as being part of the guarantee contained under Article 14, a constitution bench, then Tulsiram. Now, Millet kindly comes to the conclusion. Millet paragraph 98. At the top, Millet, kindly see the second line onwards of the same page 47 of the judgment. A reasoned order has to be issued on the objections addressed by the borrower on perusal of the facts. It is undoubtedly that the lender bank did not provide an opportunity of hearing to the borrower before classifying their accounts. Now, Millet, kindly see conclusion. No opportunity of hearing is required for FIR. I am not on that. Classification of an account as fraud not only results in reporting the crime to the investigation agencies, but also has other penal and civil consequences. Debarring borrowers from assessing institutional finance under clause 8.12.1 of the master data on fraud results in serious civil consequences. Such a debarment under such clause of master direction fraud is akin to the blacklisting of the borrowers of being untrustworthy and unworthy of credit by banks. This court has consistently held that an opportunity of hearing ought to be provided prior to its blacklisted. Now, Millet, kindly see, Millet, the next judgment. Millet, this is 2026 SCC online SC 538. Perhaps this judgment Millet was mentioning, Millet.
Yes, Amita.
Yes. Now, Millet. Now, Millet, kindly see. Para 538. Kindly see paragraph 100, where Rajesh Agarwal has been dealt with.
Yes.
Now, 100, 104 thereafter. 109.
Yes.
Now, kindly see the conclusions. 126. Kindly see, Rajesh Agarwal did not recognize any right in the borrower to personal hearing by the this is also 2 judges bench.
same strength. Now, Millet, kindly see C. The procedure set out in Rajesh Agarwal, which has been incorporated in the Master Direction 2024, strikes at a fair balance between promptitude and fairness and duly comforts with the principles of the natural justice, ensuring fairness to the borrower whose account is likely to be classified as as fraud. Wherever audit reports are available, it has to be given. Now, Millet, kindly see F. We reiterate that the rule is to supply the audit reports, including the forensic audit reports, since even under clause 4 of the master's directions, post the red flagging. Millet, I opened up, Millet, my argument today, Millet, my account has not been red flagged. Now, Millet, post the red flagging of the banks use the audit mechanism for further investigation. Even in exceptional cases, we hope and expect that the bank will not unreasonably use the person of reduction, since that will end up in delaying the culmination of the proceedings. And Millet, that this was the legal position under 2016 of Rajesh Agarwal. And Millet, it has been held that Millet, Rajesh Agarwal had not sought to give a personal hearing. But Millet, today, Millet, Millet 126A clearly says, Millet, post red flagging. So, Millet, my contention before the lordship is that, Millet, there has no been, Millet, there is no red flag.
Reply. What stand you are taken in the reply?
Show cause, Millet, reply is at 143. 143.
Yes.
Durga Pujar kotটা
Nothing.
No, I have dealt with in merits.
Then?
I have dealt with, Millet, in merits of the matter.
Then you are not stated that yes, the document has not been given, and I have a document. I will supply the document to conduct the press audit report. Where is that?
Inside last paragraph, Lordship will see they are seeking condonation of delay to respond to the forensic audit report. After all this,
That is always there, Millet. No, Millet, nobody wants to come for a litigation.
Yes.
Millet, anyway, Millet, I am before your lordship. Millet, today, my lord had seen, Millet, the document that they have sought for, naturally, they will not get. Because they have come to my office during the entire Durga Puja.
That's why I am asking you. Okay, you are not present. They have not taken in the so-called notice. You could have been, yes, they have not come. I have a document. These are the document. I am placing you, and please conduct the press audit so that. Where is that?
Millet, I have sought for a Millet. Kindly see, Millet, what?
You cannot improve your so-called report.
No. Kindly see page 140, what my learned friend was, Millet, indicating to your lordships. I have prayed for that. Kindly see the delay in making.
Not on. I am asking, see, it is now settled. Rajesh Agrawal, Iron, then our court's order, and Justice Bhattacharya order, what Kinoria, and I have passed the order. It is specific. Once you have received the so-called notice, you have to give the reply, and whatever the document you have not received, you immediately in the so-called reply, you request the authority to supply the documents, and if the authority does not supply the document, pass the order.
No, that's precisely that precisely. Kindly see the delay in making the submission, because I have gave the reply late, Millet. I think Millet subsequent to the time frame.
Correct.
Kindly see the delay in making the submission on the 150. Last penultimate paragraph, Millet.
Correct.
The delay in making the submissions or responding to the allegation, observation, conclusion of the financial auditor be condoned, and the submission made herein before be considered actively.
Correct.
The so-called
submission made in above. So where is your mention? Yes, I am giving this document, or the document is with me. Please revive the audit report so that my document can be considered. Where is that?
Millet, I am before your lordship. Millet, that can all. Millet, first of all, my first point is that, Millet, it has to be post red flagging. Post red flagging. Millet, red flagging has not been done. That's my specific contention.
Where is the, in the so-called notice, red flag, no, red flag contention?
Not there.
There's nothing. You have
Well,
dealt with on merit.
I have dealt with in merits.
Then
I have dealt with in merits. Milad, the red flagging has not been done. Milad, even the subsequent judgment of Milad Amit Iron also says Milad post red flagging. Milad post red flagging, my learned friend can Milad intimate to your lordship Milad whether red flagging has been done or not. If Milad red flagging has been done, then Milad it is Milad I am bound by the judgment.
Okay.
Milad red flagging he has to say before lordship whether red flagging is there is a procedure under chapter 3. It means it's not Milad like ways Milad it can be done. Chapter 3 has to be followed of the circular.
Yes.
But first of all, my lord, they are challenged.
One more thing, Milad, there is a supplementary Milad that Milad I intend to file. I have copy that. Acha, I'll hand up a copy. কিছু না ওই আমার আর ব্যাংকের মধ্যে এগ্রিমেন্টটা আছে, that's all. It's your document. Milad, kindly see, Milad, I'm so sorry, Milad, there is one more clause. হ্যাঁ একটু ফাইল করে
এটা নেব।
হ্যাঁ নিয়ে নে ওই ক্লজটা কোথায় যেটা এগ্রিমেন্ট বলবো
ও স্যাংশন লেটার আরেকটা ওই ইয়ে আছে অডিটর
নেই কপি নিয়ে না ওদের থেকে ডকুমেন্ট নিচ্ছে ওদের থেকে না
আমি কি
ওই প্যারাগ্রাফটা 170 4.1.2 the loan agreement Milad have just annexed the loan agreement, that's all. The loan agreement with the borrower shall contain clauses for conduct of such audit at the behest of lender consequent upon red flagging of the account in case where the audit report submitted remains inconclusive or is delayed due to non-cooperation by the borrower. Bank shall conclude on the status of the account as fraud or otherwise based on the material available on the record. So Milad, the first contention is that Milad, the borrower has to be contacted Milad for the documents.
Correct.
Now Milad, the agreement has to consist Milad a clause
in case where the audit report submitted remain inconclusive or delayed due to non-cooperation of by the borrower, the bank shall conclude
absolutely
on
Milad,
account as fraud.
Milad, I am relying on this. They have not sought for my Milad cooperation. They have simply said Durga Puja office closed, I could not contact.
Okay.
So I rely on bank. Now Milad, kindly see the supplementary affidavit once. Milad, the clauses at page 37 21A non 37 Milad. Kindly see, Milad, I am taking the responsibility on myself. Milad, kindly see, Milad, 4 lines from the bottom, starting with the word the borrower shall allow.
Yes.
The borrower shall allow the bank's chartered accountant auditor access to its office branches for all the records furnished, whatever information records required by them for the said purpose. For the purpose of these agreements, words diversion of funds would be constitute include utilization of short-term loan. No, so Milad, they have to come to me. He can't rely on Milad only bank's document. Now Milad, kindly turn the page 39. Milad, 22A.
Yes.
The borrowers understand that as precondition relating to grant of the said credit facilities, bank requires the borrower's consent for the disclosure by the bank of information and data relating to the borrowers of the said credit facilities or any other credit facilities availed of by the borrower, obligation assumed to be assumed by the borrower in relation thereto and default, if any, committed by the borrower in discharge thereof. Accordingly, the borrower hereby agree and give consent to the disclosure by the bank of all or any such information and data relating to the borrower, the information or data relating to any credit facility availed of or to be availed by the borrower and default, if any, committed by the borrower and discharge of the borrower, such obligation as bank may deem appropriate. Milad, there was no need. Milad, they have visited my office during Saptami, Ashtami, Navami, they found it closed. Milad, they have not come back. They have not thought that your office was closed. You are not cooperating with the investigating agency or the auditor. Now, Milad, kindly, and page 42. para 29.
Yes.
The borrower hereby further agrees, undertakes and gives specific consent to the bank for disclosing, submitting all information. So Milad, I am saying that Milad, whatever difficulties you had, you could have sought from me. You have come in such a situation in the state of Bengal where Milad, the offices are closed. For that reason, you have not got. And those are my submissions, Milad. Milad, with regard to red flagging at page 144, it has been mentioned, para 4. That it has not been red flagged.
Yes. You are appearing for whom?
For respondent number 2, Lordship. Auditor firm, Lordship. It's a mail dated 17th November.
Auditor has been made party.
Yes.
We have made a party. And on 17th November 2025, Lordship, we have specifically written to the Nataraj Rice Mills in their registered email ID seeking for a host of documents. May I just rely on this document, Lordship?
Next question.
It is a mail by us to Nataraj Rice Mills, Lordship, wherein we have sought for the list of the major debtors, list of major creditors, list of borrowers, electricity bills, PF and ESIC details, Lordship.
If I can maybe favored with a copy, Milad, then I can give response.
Should have annexed it. They should have annexed this.
And Lordship, in return, Lordship.
I don't know. He has to give me a copy if he's relying, heading up to the court.
Give the copy, give the copy. Yes.
I'm just carrying one single copy.
Yes. And what is the date of the forensic report? What is the date of the forensic report?
Well, at forensic report at page 106.
22/11.
22nd November.
22nd
November.
2025. And this is 17 November. Yes.
We have given them, Lordship, regarding the documents. It has not come to us. And Lordship, in return, that has been denied, Lordship, that we have not written anything unto them.
Yes.
But they are challenging an order. And reply to the show cause notice, Lordship has seen none of the grounds alleged in the writ petition has been taken. Paragraph 4, my learned senior friend, shows that red flag issue was raised. That is also not there in paragraph.
Why the red flag will not be now carried out?
Well, that is not even a ground here.
We carried out.
That is in the show cause, first forensic audit, then show cause, then reply to the show cause, then order.
No.
Show cause notice given, they don't take this point. So what will the committee decide? Committee can't decide what has not been raised. So, this point is being raised in the writ petition.
Red flagging has to be done.
And whatever the contentions were there in the reply to the show cause, everything has been dealt with in the order. And my learned senior friend has not made any submission on merits, so I'll not address the Lordship on merits. Lordship will see the findings recorded in the order. There are absolute allegations of fraud and findings. Not only hypothetical situation, there are findings to that effect. But I'll not trouble you, Lordship, because it has not been argued. Now, insofar as the supplementary affidavit shown, it has been submitted by showing page 37, that the bank has to call upon them asking for records. Kindly seize the portion which my learned senior friend has placed reliance on. Page 37, clause 21A.
Yes.
Learned friend has relied on the borrowers shall allow the bank's chartered accountants, auditors access to its office, branch offices, and to all our records.
I'm saying
to ask. No, it's not that I will have to ask them to access our records, the bank's records, which the forensic auditor has done. Access our records. This was skipped by saying all the records.
Bank chartered accountant and to auditors access to its official
to its offices / branch offices and to all our records and furnish whatever information records required by them for the said purpose. Required by them. It is required by the auditor. Whatever information is required, they will ask from the petitioner here or the bank. Bank has supplied, petitioner has not.
So, my lord, I do not, my lord, there is no infraction of any of the my lord, rules which have been cited. And my lord, insofar as the red flag issue is concerned, this is an afterthought. But first time it has been raised in the writ
If
petition,
something
that
has
cannot
not-
be improved.
Something has not been done, that has not been done. So, red flagging is mandatory. Even if I don't take the point, it's like point of limitation.
And my lord,
Even if I don't take the point of limitation, the court will have to decide on the point of limitation. It's a point of law, red flagging.
Insofar as
But the problem is that, okay, it is the point of law.
Law.
As per your case, the first duty of the authority bank is to
Red flag.
to red flag.
Red flag.
And red flag, it
Has not been done.
so that you can rectify the account
Absolutely.
during that period of 20 days or 15, whatever it
Absolutely.
is. So this is your case. And without the red flag, immediately this
Kindly also say, there is also no reply on that. This also their case, the red flagging has not been done.
Correct. No, that's
Red
not
flagging has not been done.
That's why, but your case in the return, this Soka's reply, you have not made out a case, sir. See, you have not made a red flag.
No,
so that I
kindly
could
see
not-
page 144.
I could not get an opportunity
Kind-
to rectify my
Let's
account.
suppose,
also, my lord, this defense that their offices were closed during Durga Puja, that has also not been taken in the reply to the show.
Kindly see page 1. That is admitted. If somebody says I have not done, what defense should I take? May I put the question myself? And kindly see page 144. It is denied and disputed that there is any major discontent or significant red flag. They have said that I have red flag, I have denied this. Now, even if suppose point of limitation, a party doesn't take. It's a court duty, subject to correction. It's a settled law.
That is the point. That is the law.
Similarly,
that is the law. But here the fact. What is the fact? Your case, you have filed the present writ application challenging the order in the 2-3 facts. One is with regard to red flag was not done. Okay, not done. Then the so-called notice, the auditor has visited, but he has not taken the document from you. Correct. Third, you have given the detailed reply to the so-called notice that has not been taken care of. This is the 3 things you have argued.
Absolutely.
Correct. With regard to the red flag, okay, that let the court will see whether red flag will vitiate the procedure or not. That will see. With regard to the document is concerned, you have, okay, the bank has not taken the document from you, but you have given a detailed reply to the bank. You have not stated to the bank, sir, see, these are the documents. Your auditor has not come forward for taking the document. See, I am giving it to you and to conduct a further.
I can give still now. Now, kindly see 2026 judgment, which is now ruling the field. F.
Yes.
It specifically says that master direction has to be followed post the red flagging.
Correct.
So it's a mandatory issue.
Correct.
Whether I'm taking the point or not taking the point, I can always take the point before your lordship.
Okay.
I'm questioning the non-red flagging before your lordship.
Okay.
And there is no answer to this.
Okay.
Because it has not been red flagged. If it has not red flagged, the subsequent procedure formula falls on it.
Okay.
And only upon red flagging, an auditor can be appointed. Then auditor comes. If a red flagging has not been done, auditor cannot be appointed. Kindly see, the 167, page 16, this master circular. Kindly see one. Yes, 169. 169. In case of chapter 4, in case of a credit loan account classified as red flagged account, bank shall use an external audit or an internal as per the board. So, the first criteria is red flagging.
Yes.
Red flagging has not been done. And red flagging is not a procedure that I am sticking your label on your forehead that red flagging has been done. There is a procedure, chapter 3, at page 167.
Yes.
And this has admittedly has not been done. As of now, it appears.
Okay.
And if red flagging is not done, subsequent steps falls on it.
Okay.
Supreme Court judgment also says the same.
Yes, why the red flag is not done?
The red flag issue, my lord, I have given in the show cause notice that in paragraph 2.2 and subparagraph 2, I have given that this is a major disconnect and a significant red flag, which was
Where?
my lord, page 101 is a part of the show cause notice.
Yes.
Paragraph 2.22, then there's a chart. What you will see on the second paragraph of the chart. For nearly 7 years, such and such company receivable, such and such. The kindly sees the last sentence, second last sentence. This is a major disconnect and a significant red flag. It indicates that the company's ability to collect money from its customers collapsed dramatically in that 1 year. Now, this was barely denied in the reply to the show cause notice. It was not for once alleged that the procedure for red flagging and EWS, etc., has not been done, so that vitiates the entire proceeding, etc. It was never alleged. So it was not for the bank to consider while passing this fraud classification order as to whether it was red flag or not, because this issue was not even raised.
Yes.
On the contrary, it was contended by the bank and was evasively denied by them.
Yes.
I mean, after nothing else. Well, the clauses also show, and
It has not been done.
Okay.
It's apparent.
No, well, that is not the
Red
case.
flag
That is
has not
only an
been done.
allegation,
There is a
and it was
procedure.
not there before
There
the
is a
fraud
procedure.
classification committee. It was not
Milad,
there.
there is a procedure to red flag that has not been followed. Now, Milad, coming back to the judgment, Milad, the Rajesh Agarwal judgment says, Milad, personal hearing. The subsequent judgment says, Milad, no, giving SCN is okay. Milad, I'll rely, Milad, only on Milad, issue of Milad, not really Milad, the judgment passed by a coordinate bench is binding on a subsequent bench, having a same strength. It's a point of law. Milad, and Milad, the judgment, it's the same strength of two judges, same strength of two judges of the subsequent. Now, Milad, if this kindly see this judgment of 2001 6 SCC, page 356.
What you want to say?
Milad, I want to say, Milad, the first judgment says, Milad, personal hearing. The second judgment says, Milad, no, personal hearing is not required.
Second judge, it is not said that the personal hearing is not required. It depends upon if you are. But it is personal hearing does not the opportunity of hearing does not means the personal hearing. That is the Amit Iron says.
Nah, yes. The first judgment says
is the
personal hearing.
The second, it was said when it went to the Supreme, the other matter, the Supreme Court has stated that merely the personal hearing does not mean it. Merely opportunity of hearing does not mean a personal hearing. Personal hearing, if the required, it can be given the personal hearing.
What more case to be made out, Milad? My red flagging has not been
So
done.
your repetition in your so cause notice, where is the personal hearing request?
Milad, there is, Milad, my red flagging.
You have not done anything in your, not pleaded anything in your so cause notice. Now you have, when the client came to you, you made out a further case in the writ petition, which is not in the so cause reply. How the court can adjust that?
Red flagging is a mandate of law.
In the so cause notice, the bank has categorically stated that due to your conduct on the account is significantly, it is a red flag. If the significantly
Yes,
it is
if
a
the
red
usage
flag,
of word
even
significantly, it's a red flag.
even in that you have given the reply, you have not stated no red flag procedure
for
is
that,
and you have not followed
Milad,
it.
for that, there is a procedure in chapter 3.
Correct.
Milad, chapter 3 has not been followed.
Okay.
Chapter 4 comes later on. Milad,
Getting concluded CAB.
Very. दे दीजिए तो. Paragraph
concluded CAB. Next,
Milad, of that, Milad.
I think if your lordship so requires, well, red flagging has been done. Well, I've got instruction from the bank. Red flagging has been done. If your lordship requires, well, I can file that. Well,
I will record your submission.
Very well.
That Milad, he has to show that red flagging has been done.
Yes.
Milad, paragraph 23 of this 2001 judgment kindly keeps a note. Paragraph 23.
Grateful.
Right.
Yes, who is for the item number? 19. Who is? Okay, band karo. Appellates at close.
Lordship, with an innocuous prayer, Lordship, item number 13, I was waiting for the matter, but due to the resolution which has been adopted during this tiffin break, your Lordship, we could not appear, and this matter has been, item number 13, has been listed on 6th of August.
Item number?
13.
13,
your Lordship.
Let
this matter appear
6th
tomorrow.
August.
My lord, let this matter appear tomorrow, your Lordship. My lord, due to the resolution, my lord.
Maybe take resolution. I am not against the resolution. I am going by my cause list. Tomorrow, I will give this tomorrow. The tomorrow list where we will go when I already given the date to the other advocates. where I fitted that.
My lord, will kindly any prior day, your lordship, I'll intimate the respondents, your lordship.
Yes.
My lord, will kindly consider that it's a retired lady, 40 lakhs of rupees,
Maybe.
your lordship.
Either you go by your client, or you go by your bar association, or you go by your brief. The court is here. And it is not this attitude of this court not here since the beginning when I have been elevated. It is not the new attitude of the court. You have taken the resolution. You have taken the resolution. I have not dismissed the case. There no adverse order is passed. It has been shifted to other date, because if today's 50 matter is shifted to tomorrow's 50 matters, tomorrow 50 matter, where it will go? Appreciate the situation of the court.
I appreciate lordship.
All advocates are having all urgency matter. And tomorrow morning again 100 advocates will mention the 150 matters.
Well, let this matter at least
Yes,
appear
yes,
in the
Calcutta.
next week, your lordship. My lord, kindly lordship consider that.
Well, the first matter, which is fixed at 3 p.m. also.
Yes.
Now, my lord, Mr. Mitra is there. My lord, if your lordship wishes, my lord, then do it. Otherwise, lordship fixes a date, my lord.
कब होगा?
हाँ, 3 p.m. fix है. Only request now, my lord, we have suffered a lot. If any
I
day-
also wondered this
Yes,
was, but
yes.
what can be done?
Well, any day from 2 p.m., my lord, that is, my lord, the court is ready to take up, other side is ready to do it, I am ready to do it. But then it comes not to participate.
That's I'm telling.
Any day at 2 p.m., my lord, we can finish it at finish.
If 2 p.m. can't be, because original side starts at 3.
Or, my lord, may I pray for this, my lord, any Tuesday or Wednesday at 2 p.m. to take a chance, my lord. Thursday becomes weekends, my lord, nowadays.
Chances of 3:30 reduces, my lord, if it's Tuesday and Wednesday.
2 p.m. নেন না 3টে থেকে নেন. Lordship
13 August.
Any date.
Has it done? 13th August, 3 p.m. 13th August, 3 p.m.
3 p.m. not. Is it a Tuesday, my lord?
Thursday,
Thursday, my lord. Any day, Monday, Tuesday, Wednesday, I'm before my lord, both of us.
then
Me and
17th.
Mr. Mithro. Earnest request.
Then 17th August.
17th August at 3 p.m.
Monday.
Very well. Grateful.
Though the matter is specifically fixed today at 3 p.m. But due to the bar resolution, commandant and advocate appearing for the parties not appearing, the according cases adjourned. Let the matter appear on 17th August 2026 at 3 p.m. as specially fixed matter.
Grateful.
May I also have the liberty of mentioning, my lord, since your lordship indicated, lordship possibly would sit till 3 o'clock to check, my lord, whether interim orders are expiring on. My lord, this is a 3:45 fixed
If
matter.
the advocates are ready, then but I told the original side will take at 3 p.m. Somebody has mentioned.
So, my lord, this interim order is expiring, my lord, today.
Which matter?
My lord, it's item 2 and 3.
Fixed at 3:45.
Both of us are here, but
I'm suffering the consequences, but
there is another difficulty today which my learned friend is facing, my lord.
So I don't want to say.
My lord, very well. That's a personal difficulty, my lord. That's the reason, my lord.
So when? 3:45 kab hoga?
Any other day as per your lordship's convenience.
We can take the 13th August 3 p.m. slot, my lord. 3 p.m. suits us.
3 p.m. Okay.
Record an order. 2 and 3, yeah? 2 and 3 both?
2 and 3.
2 and 3 both?
Yes.
Though the matter is specially fixed today at 3:45 p.m., but due to bar resolution, matter could not be taken up for hearing. According cases adjourned.
But I have one prayer to make before lordship. There is a vacating application to his petition. Now, on the last occasion, Mr. Thakkar, who is leading me in the matter, had indicated before lordship, let our vacating be treated as an opposition to their application and let them file a short reply.
My lord permits me to
Prior
fix time,
to-
my lord.
prior to the
meantime,
next
you
date. Yes.
let the matter appear on 13th August at 3 p.m. In the meantime, the respondent, the petition's liberty to file affidavit in opposition to the CAN application and to G application filed by the
Reply. It should be treated as reply because my
The
vacating
affidavit
be treated as
treated as opposition or give a reply.
क्या बोला? Full stop. Okay, full stop. Okay, full stop. The counsel appearing for the bank submitted. The bank has filed an application for vacating the interim order, but she submitted that this said application may be treated as affidavit in opposition of the main application. Accordingly, the petition director filed reply to the said application, and the application filed by the respondent shall be treated as affidavit in opposition of the main application.
Great.
Release the matter on 13th August at 3 p.m.
The
interim order may be
Order is
till that.
extended till
17th, my lord.
My lord will kindly consider the
Since it's on 13th,
predicament
my lord,
on
only
my
2-3
part.
days window, my lord.
Otherwise, let it be returnable on 13th. My learned friend can come and mention like today.
Come on that date.
Yes.
Till
Let
the
it
next
be
date of hearing.
extended till
Till the
that
next
date.
date. Okay, very
Grateful. Right to appear instantly now, no?
Yes, next.
Yeah, my lordships, kind leave to mention this matter appearing as item number 81.
Yeah.
Only, my lord, seeking a direction upon the CPWT to consider my representation, my lord. The very short matter, my lord.
Which matter?
This is these applications filed.
Want to include?
Want to include in tomorrow's list, Your Honor.
Why? What is the urgency?
Urgency, I have received an eviction notice dated 7th July,
Kal kar.
and they have much of.
Kal kar do. हाँ.
My lord, this matter, my lord, only
81.
81, my lord. Only seeking a direction upon the
Because the
CPWT.
other side.
My lord, I'll intimate, my lord. I'll inform the other side, my lord. This has been
Oh.
pending since a long time, my lord. I have precedents, my lord. I'll show it to your lordship. Won't take more than 2 minutes, my lord. They are binding precedents.
So what you want?
Other side, my lord.
If other side is that the today itself, I will dispose of with only consideration.
My lord, today the matters which have been fixed, they are not coming. Any day, my lord, subject to your lordship's
81
convenience.
में ना कोई एक दिन ऊपर to be mention में कर दो देख.
My lord, similar, my lord, pair in this, my lord, 128, my lord.
देख लो.
Same.
If only consideration, then I will see.
Yes,
Then-
yes, yes,
Then
yes, yes.
again it will go.
Yes.
Yes.
Great.
Okay. Yes, call the matter. In any matter, both advocates are there? Any of the matter? No. Okay, call the one. Can now?
That my affidavit of service mentioning, my lord, at 1:15 on notice, they were present. And again, we gave notice. So they are aware.
Who is appearing?
Mr. Shubhankar Nag. My lord, it's not contempt of your lordship's order. My lord, they wanted to throw us out. We came running to court with the writ petition. When we moved, they said that we are not going to throw them out by force. We will take them to the estate officer. And matter was to be heard. We said, fine, there's no problem. You go to whoever you want to. But before that, my matter will be heard. So my matter was taken up for hearing. And 9th March 26 and 17th March 26, we concluded our submissions. Milord, page 17, Milord, of the application, we concluded our submissions. Then, Milord, the matter has been in the list.
Yes.
Sorry. My lord, Mr. Nag is leading me in this matter. He's on his legs, my lords. He's requested for short passover.
He will come.
He'll come, my
He's not on his legs.
court's 6.
I'll wait, Milord.
Okay, you argue. I'll take note of it. I will hear Mr. Nag, no problem. Yes.
So, Milord, the matter has thereafter been in the list. I do think, Milord, on one or two occasions it was called on. Some difficulty of my learned friends, Milord, they could not make their arguments. But I had concluded, Milord, on 17th March 26, page 17 of the application. In this situation, I suddenly, Milord, get a notice yesterday in the afternoon. That is at page 41. One for, Milord, termination, one for damages, the usual. We get it yesterday and hearings today at 3 o'clock. Now, Milord, directing me to appear today, less than 24 hours notice. Now the issue, Milord, is this. If your lordship, Milord, if I tell your lordship would recall, I was, my lord, a lessee of three plots.
What is your main earlier application? What
My lord, writ petition,
prayer in that?
writ petition prayer is, my lord, kindly see, my lord, at page 37, 38 of the writ petition.
Cancel, recall, and revoke the
The
notice dated
notice,
24th February.
and my lord, the most important prayer is F, that they have to pay me, and G. G is my prayer, which I want. I'm fighting for G. Writ of or in the nature, writ of mandamus do issue commanding respondents to forthwith act in terms of clause 16 of the land policy guidelines and take steps to publish, conduct and conclude tender auction in respect of these plates where I am, my lord, in occupation. Because my right is, once, my lord, my lease comes to an end, under clause 16 of the guidelines, they have to decide if they want it for themselves. If they want it for themselves, I have to go. If they don't want it for themselves, in that case, they have to hold a tender. And I have a right to match the highest offer because all my tanks and installations are there. It will be of special value. So, but I have to get it at market value. So, my lord, I have a right to match. Now, my lord, what has happened in this case is, after all three plates had lapsed, I continued in occupation. They, my lord, did not hold a tender. Umpteen letters from my side asking them to, my lord, hold a, my lord, start a tender inquiry. In between, what has happened is that under, my lord, they have something which is, you know, there, which is called TAMP. Their, my lord, rates are, my lord, revised. So TAMP rate I was paying. TAMP revised the rate from, my lord, 6,300 to 1,000. So with 5 years retrospective effect. So for 5 years I paid extra. So now they would have to adjust or pay me. They didn't do either. They did not raise a bill for, my lord, 3 to 4 years. Then one day they raise a retrospective bill for 3 years or 4 years and they put penal interest. So I said that as per the TAMP rate, it's gone down. You have to at least, even if you don't want to pay me back, you have to at least adjust. If you adjust, I'm not, even then I am in the green, I'm not in the red. So how can I, my lord, have to be called upon to pay interest? Now they continue to levy, my lord, penal rates. And ultimately, I filed this writ petition asking for, my lord, enforcement of the land policy guidelines. There they say that no, I won't give you. Why? Because you're a defaulter. I say I'm not a defaulter. Because land policy has been revised, because the TAMP rate was revised. So if you adjust my extra payment, I'll never be in default and you can't charge penal interest. So, my lord, to avoid now, my lord, auctioning the property with me having the right of first refusal, they, my lord, are calling me a defaulter and taking me over there. This is the matter. Now, enforcement of clause 16 is a matter which cannot be done before the estate officer. That is only before your lordship.
Yes.
Until today, I am paying.
But the notice which you have filed this application.
Yes.
This is a Public Premises Act. How this court can entertain this?
My lord, I'll just, my lord, yes, it is possible because it's in the during the pendency of a writ petition, having notice and knowledge of my writ petition, and where we have concluded arguments in March. Now they understood that they couldn't proceed. Now to suddenly, my lord, beat the court in a race is
Correct.
not proper.
You could have been filed before the appropriate court informing all these things pendency of the writ. Why you not done so?
I can do that. My lord, I am not here, my lord, to ask for absurd interim orders. I feel my case is strong, and if writ hearing is concluded, then, my lord, this whole proceeding will go because this adjudication your lordship is doing here as well, to understand whether I am a defaulter. So, my lord, I have sent my advocates over there today to ask for an adjournment. I am certain, my lord, that the matter will be adjourned, having regard to the fact your lordship was pleased to permit us to come. My lord, if your lordship keeps it, my lord, on Monday or tomorrow, for my learned friend to conclude, I am sure adjournment will be for 7-8 days. If it is an unreasonable one-day adjournment, I can always come back. And my lord, writ court always has the power. I don't want to, my lord, ask for, my lord, exercise of that. I'm only asking my learned friend to complete, to, my lord, ensure I don't have to, my lord, give a longer reply. I'll prepare a note and just deal with his arguments. So, my lord, kindly permit it. I think there's a completely bona fide approach.
Yes. My lord, kindly have a look at the writ petition first. My lord, my case is barred by alternative.
Barred by?
Alternative. Because the proceeding has been initiated under section 4 and 7, and under the statute, the authorized officer is competent to deal with whether the eviction or is to be carried out or what is the deal. Now, my lord, to avail the remedy before your lordship, kindly look at the pleading. The petitioner may place it, madam. Paragraph 36 of the writ petition.
Yes.
The petitioner may place it. Petitioner have no other alternate efficacious remedy and reliefs, and prayer for hearing if granted will afford complete remedy to the petitioner. The action or actions of the respondents have public law elements attached to them. The petitioner, very important, are in any event being stopped from availing the remedy provided by the Public Premises Act and conducts of the respondent.
It should be the other way around.
Now, when the proceeding is started, now they are saying, they are stopped. Now, that is number one. Now, in support of that, one judgment of the division bench I'm going to rely on before your lordship. Kindly have this judgment reported in 2009 SCC Online, Calcutta 266.
Get a copy down.
Copy down. Kindly have that. I have just a few paragraphs I will place. Paragraph 19, I'm placing where the issues have been jotted down. The eighth, has your lordship got that one? Paragraph
Yes.
19. The area respondents, the writ petitioners say that they have a very short question had raised before the learned single judge and decided in their favor. They assert that a landlord, which is also a state or authority within the meaning of Article 12 of the Constitution of India, is precluded from acting as any private landlord driven by mere profit or commercial motive. They say no action of the state may be uninformed, particularly if it is exposes a citizen to harsh consequence of being removed from a place of business. The writ petitioner contended that there is a statutory authority. Landlord seeks to determine the lease and terminate the authority of an occupier to remain in public premises. It ought to afford the lessee or the occupier a chance to present his version of the matter and thereafter take an informed decision. The emphasis is on the principle of natural justice that a statutory authority may not suo motu take a decision without reference to the lessee occupier or without allowing the lessee occupier to participate in the process, culminating in the decision to determine the lease, terminate the authority, remain in possession. Well, same as here. Now, let's kindly come to paragraph 25.
Yes.
If the said act or special provision as enshrined therein when not there, the state or any authority under Article 12 of the Constitution as a landlord or owner of any public premises would, in such circumstances, is governed by the provisions of Transport of Property Act and have recourse to the procedural law under the civil procedure. In the absence of any special enactment like the Rent Control Act, any other statute, the landlord may determine the lease or issue notice that any occupier on his premises was no longer welcome. The determination of the lease or notice to quit the premises would not ipso facto entitle the landlord to resume possession of his land unless the lessee occupier voluntarily succumbs to the demand. In the usual course, a landlord would be required to file a suit and justify therein his decision to determine the lease notice to quit, await decree, and if successfully. If there is no dispute here, and it is implicit in the writ petitioner argument that if the land in question is public premises, the manner of eviction provided under the said act of such and such. What is in dispute is whether noticee under section 4 of the Act can question the decision of a statutory authority landlord to determine the lease or terminate the authority remaining in occupation of the public premises. Since the parties have agreed, I am skipping this portion. Now, my lord, kindly come to paragraph 28. After Ashoka marketing case, the question that is posed here should scarcely have risen. For the doubt is now settled in such and such judgment, though an estate officer under the said Act is not required to be versed in law, he has sufficient power to decide the question as to whether a noticee under section 4 of the said Act is an unauthorized occupant and it is the adjudication on such score against the noticee that will permit him to proceed to evict the occupant adjudged to be unauthorized. Just as in the case of any landlord governed under Transport Property Act, such landlord would have to justify his decision to determine the lease or terminate the authority of the occupier to remain in possession in a civil suit instituted either by the landlord for eviction or by lessee occupier to challenge the notice. So it is the statutory authority landlord under said that the said Act merely removes the authority of the civil court to adjudicate such issue and place it before the estate officer under the said Act to decide the matter in summary proceeding. The estate officer has to look into all material before him and in a fit case receive oral evidence before he can arrive at a conclusion as to whether the noticee under section 4 is unauthorized occupation. If he holds that the noticee is indeed unauthorized occupant, he proceeds to remove the noticee and his belongings from the public premises. If he finds that the noticee is entitled to continue in possession, the matter is over. It is only entire scope of adjudication on such issue it removed from a civil court and placed before an estate officer. The substantive law under the Transfer of Property Act may still be cited before the estate officer and taken into account by him for the purpose of his administration. Now, let us skip this portion. Now, paragraph 29. As always, any act of the state or instrumentality of the state has to answer to the demanding standards of Article 14 of the Constitution. And the notice under section 4 of the said Act is not precluded from urging such ground before the estate officer. Well, it's a conclusive determination by the division with the entire purpose of the estate officer issuing notice to the alleged authority.
No, that is correct. See, with regard to this notice, but in the writ petition, there is no question of the Public Premises Act. What is the writ petition?
The writ petition, well, I see. Now, writ petition, they are claiming that according to the land policy, if you give the land to somebody,
correct,
then I have a right.
Correct.
Now, the issue in the notice or adjudication is not that. It's not that I have the authority has decided to give the lease to somebody else. He is putting the horse before the cart or the cart before the horse. So what I will do.
What the notice you have issued?
The notice, Malad, that is Malad, 2 paragraphs, Malad. The conclusive finding, Malad, then Malad, I will go back. Malad, paragraph 33, Malad. In view of the bar, under section 15 of the Civil Code jurisdiction to entertain smooth proceeding in respect of eviction of any person who is unauthorized occupation of any public premises, if the estate officer does not have any authority to adjudicate as to whether a person is in unauthorized occupation of the concerned public premises, it will lead to an analogous situation with the writ court being the only forum available to the alleged unauthorized occupant. Such an interpretation would leave the said Act of 1971 very vulnerable. The estate officer must be seen to have power to adjudicate the fundamental issue as to whether a noticee under section 4 is unauthorized occupation. It is only upon such interpretation of the said Act would be a complete code in respect of matters relating to determination of lease of any public premises or termination of authority to occupy the public premises and the consequential eviction of the occupier upon being adjudged to be unauthorized occupant. Both Ashoka marketing judgment support that. That is not to say, well, the next paragraph, well, is not important, but here these 233 is Malad clear. Now, Malad, I am placing that next. That is not to say writ petition would not be maintainable if it challenge landlord decision to determine that it is related to public premises, terminate the authority to be in occupation of the same. But the writ would usually guide the petitioner to the alternative forum before the estate officer. So this is the proposition. Now, Malad, if at all his submission that see I am supposed to get this, he can urge this before the estate officer. It is not barred under section 4 that these issues will be adjudicated by the estate officer and this issue will not be adjudicated. The court says, well, the division bench and also the Supreme Court. So it's a complete court. And well, when the
that is not the disputed. That is not the disputed with regard to the if you have initiated the proceeding under the Public Premises Act, the authority will decide its own fact. If it's not considered, appeal provision is there, whatever it is. Now here the question, that's why the what applications today he has filed. The first question I put to Mr. Chaudhary with regard to the section 4. Now the what is the writ petition? Writ petition is not with regard to the public premises. Writ petition with regard to the your tender and the your scheme.
No,
So
no,
whether-
I have not, Malad, just a correction. Malad, I have not issued any tender. I have not even thought
So
of.
that's why what is the cause of action in the writ petition?
Allow me. They have challenged in the writ petition is the notice to quit. Malad, here
Correct.
also, Malad, the judgment are just placed. They have challenged the notice to quit.
Yes, kindly come which is
Prayer, Malad, kindly come to page 37 of the writ petition.
Yes.
Prayer B, a writ in the nature of mandamus be issued commanding the each of respondent to forthwith withdraw, cancel, receive, recall the notice dated 24th February issued by the respondent number 3 being part of such and such. Now, if Lordship kindly come to
That's because of prayer G.
Kindly come to the 24th February 2026. Where is the notice?
just remember, Lordship will find at page 303.
Okay, second volume.
Volume 2. Volume 2. Kindly come to page 303. Well, can a section for notice be challenged before a writ court?
No, that's why I'm saying where is the notice?
Well, I'm thankful to you, Lord.
Where is the
But kindly
notice?
come to see. Well, whereas the property description is in the first paragraph. By remove that. By skip that. And whereas, well, you have failed and neglected to pay a sum of rupees blank 3 crore 93 being amount of rent taxes from the period of and a sum of such and such towards secured interest on such and such. Now, therefore, I give you a notice to quit and vacate and deliver a vacant and clear possession of such and such to authorize representative of such and such or nominate the above scheduled property. It may be mentioned no alternative but to place a matter before estate officer, the adjudicating authority under the public premises. And now what he is claiming? Now he is claiming before your lordship. See, he is saying that this 6 crore is not even payable. And therefore, he is entitled to regularization. Now, my lord, what amount is due is, my lord, subject matter of section 7 and my lord, section 4. Now, my lord, today in today's application, my lord, what they have challenged, my lord, kindly come to the today's application here. Now these two proceedings have been initiated. Now they say, kindly stay this proceeding. Now, my lord, lordship will find prayer A, an order be passed staying all proceedings in proceeding number 2240 224B purportedly initiated by the respondent number 1 till disposal of the writ petition. Now, my lord, what are the proceedings? They have, my lord, pleaded that in lordship sees.
No, this 303, which is under challenge in the writ petition, that is not issued by the state office.
No.
That is not under the Public Premises Act. 303 or
It
305.
says we will go to the estate offices. So that can always be challenged.
Yes. Now, my lord, today, my lord, to be very, my lord, here, my lord, I say an amount of this is due, X is due. He is saying no, X minus Y is due. Well, who will decide that? A writ court.
So that's why, that's why saying what the court, what I feel, once done, the notice which you have issued 303, 305 is the pending adjudication.
Pending adjudication.
Correct. Now you have issued the section 4 notice, section 7 notice.
Therefore, thereafter the process, when the act says, I have to approach before the estate officer.
Correct.
By filing a plaint of mine.
Correct.
Saying that this is the ground for eviction.
So you have to refer the matter to the estate officer.
Estate officer passes an order that you issue notice under 4 and 7.
Correct.
Now that has been done by the estate officer.
Correct.
Now they are before your honor, before your lordship, saying that now they want a stay of this section 4 and section 4 and section 7 proceedings. So thereby they are saying that the process of eviction and process for realization of damages should be stayed. So this is the prayer. Now this prayer is also barred under specific relief.
That's why my question is you, before not to you, the notice which you have issued on 24th February 2026, there was no state case initiated.
No.
Correct. Only you have informed the petitioner to vacate the premises and this is the claim.
No.
Correct. Now they have challenged that whether the notice is bad in law, whether the petitioner is required to pay or whether you are required to pay, that is to be decided in the writ proceeding. But the subject matter is same. So if the matter is why, because it is a final hearing, why you cannot stay your hand for the 10 days or 15 days, let the writ petition proceeding be over.
That challenge section 4 notice.
Here in that's why I'm asking the judgment which you are referred, there is no dispute with regard to the proposition of law. Here again and again telling the 303, 304 is not the notice of the Public Premises Act. This is the authority's notice. Authority notice cannot be taken as a Public Premises Act. Now you have started the public premises. So I am asking you, once your first notice which has been initiated by the authority is under challenge before this court, and on the last occasion, Mr. Chaudhary has argued then, and he wanted to state that we are of the view and this court is of the view. Now it is going to be disposed of. Nothing is. Now you again issued. Now have started the proceeding. Suppose this and the writ petition will be delayed and the eviction process is started. So what would happen to the writ petition?
Well, I tell you, lordship, there was whatever is falling from your lordship is absolutely correct. But my lord, as there
this court is not going to adjudicate with regard to the 4 is correct, 7 is correct. My only direction is how. My only concern with regard to the how, pending this writ application, if the state officer continue and this writ petition will not dissolve, what purpose would be served with regard?
I tell you, they should have waited, but there was no stay order also.
Correct.
They works mechanically, basically the officers. If, as they have seen, there is no stay order, they normally proceeded. So they could have filed any expedite the hearing before this court. Well, that they did not.
Because on the last, the final stage of Mr. Chaudhary has already concluded his argument on the last occasion 17.
Well, I have also concluded.
Yes,
I have nothing more to say.
So I will fix a date so that matter can be disposed of. You do one thing. I am let you stay your hand. You give the written notes of argument by tomorrow or Monday. I will deliver the judgment.
Yes. My name, my notes and 5 minutes, and that's it.
When you will come, tell me. Then I will fix accordingly. Give both the written notes of argument.
I have placed the main judgment before your lordship. My contention before your lordship. Two things, three broad details. One is alternative remedy. Here, I am supported.
No, see,
Number two, I am concluding my submission.
Correct. Now, with regard to that, so I am telling alternative remedy with regard to the state Public Premises Act. Public Premises Act, they cannot directly invoke the Public Premises Act. Correct. Unless and until you initiate the proceeding, then they can appear before the public state officer and they can continue with the matter. Here in this, when that's why the impugned order 24th February 2026 order is not the state case, not the state case. So that's why whether that notice is correct or not, let them decide it.
So why also in that 24th of February 2026 notice, which is under challenge, under by that notice, what is the alternative remedy as per you?
I'm sorry, Milord.
24th February 2026, which the petitioner has challenged. So what is the alternative remedy of that notice?
I tell your lordship why it is alternative remedy is part of it. Yeah, my lord, in the notice itself, kindly, my lord, revisit the notice once. It is a precursor to the proceeding, and it has been mentioned in the notice itself. 304. My lord, kindly see. It has been clearly stated.
Yes.
It may be mentioned that there is no alternative but to place the matter before the
State officer.
The adjudicating authority under the public premises in case of default in compliance as above on part of notice in view of bar under court jurisdiction under section 15 of the Act in recovery of etc. as defined in the said Act. So I have said that I will issue the process. Now, my lord, there are two things, my lord. One, my lord, is, my lord, kindly have a look at section 15 also. The section 15, my lord, kindly have a look at section 50 of the Act. আছে?
এই যে আমার কাছে আছে।
আমার বইগুলো কেন সরিয়ে দিল? Kindly have.
Yes.
Most court shall have jurisdiction to entertain any suit or proceeding in respect of the eviction of any person who is in unauthorized occupation of any public premises. The removal of it's not important. So 5A is important. So, if in the notice I have stated that this matter is a matter under section 15, they can
Correct. I am telling you, correct. You should. So let the court decide whether this notice is correct, whether you can refer the matter to the state officer or not. Let the court decide. If referred automatically, you the state officer.
I am just concluding my summary. I have nothing more to say. Here, now he has to cross the test. The test of alternative remedy. He has to see that there has been a violation of fundamental. That is not.
That is not here.
That is not. Now, the only violation complained of here is that I am charging excess, and as I am charging excess, I cannot avail the benefit of the grant of this.
No.
So, if that be so, this exercise has this. This is a disputed question of fact. Now, he says, in terms of the lease, I am supposed to pay 1 invitation. And the statute say, or section 49 of the Major Port Trust Act says, the camp has to decide what should be the amount. Now, if somebody is unauthorized or lease is expired, then you are supposed to pay 1 into. So, this is now whether 1 is correct. 3 is
That's
correct.
why.
So that's why I'm saying, here. So this writ petition was filed just to stop the proceeding under the. It's nothing else. If lordship sees, if the main demand notice goes, obviously I cannot issue take steps on the. So they are basically diluting the statutory power which statute has given. So they don't have a case that there is a violation. They cannot say, I have also asked excessive of my jurisdiction.
Mr. Nag, that's what I'm telling. The court is totally agree with you, but only the once the proceeding is pending.
That, I agree to your lordship. That I agree to your lordship.
That I am not telling with you. The court concerned with regard to once the writ petition is pending, and this court has not passed an order because the final hearing was going on.
And it will be disposed of.
In that event, my lord, kindly pass an order in the disposing of the writ petition. He has concluded.
Yes,
and
yes.
also concluded.
Yes, so I'll come back on Monday with my note. Take 10 minutes, my lord.
Conclude the hearing.
No, Monday we'll come back with the note and finish.
Both the parties have concluded their argument. Full stop. Parties are directed to file their written notes of argument on 13th July 2026. List the matter on 13th July for filing written notes of
My lord, only
as the writ petition is at the final stage, accordingly, the respondents are restrained from proceeding with the state, proceeding with the proceeding initiated under the Public Premises Act till the final order of this.
Lord, only one request. Your lordship recorded, concluded. I want to Lord, give rejoinder submissions. I'll bring it in my note. Take 10 minutes.
Bring the report.
Lordship,
Give in the report. Give in the reply.
Lordship will hear me for 10 minutes. 5
For
minutes.
what?
5 minutes.
5 minutes, then it will go again 15 minutes.
No, 5. No, 10. Lord, let me be truthful for once regarding time.
Come.
Just 10 minutes.
Lordship, grateful.
Monday I'll come. Lord. 10
Monday fit to be mentioned.
To be mentioned. Grateful.
I noted 7 arguments. I'll deal with them.
I will also, my lord, indicate my.
Give.
Before your lordship calls on the list, Milord. Before your lordship calls on the list, the regular list, matter fixed at 3 p.m. Milord. I have, Milord, one urgent mentioning, if I may, lordship permits me. Milord, at present, the Waqf tribunal is not functioning. Now, Milord, I am a developer who has developed G+4 storage building from 2014. Now, power of attorney not given to me. I receive a notice from the Waqf board that you hand over possession by tomorrow. It was a 7 days notice. I was supposed to, Milord, get it at least 7 days time to hand over.
Why is the writ petition?
Waqf tribunal is not functional.
Why?
Because, Milord, the quorum is not there at the moment. So, Milord, if I have to, Milord, have any allegation against the Waqf board, I'll have to come before your lordship. Unfortunately, trouble more. It's already burdened.
Go to the original side. Go to the
this original side.
Suit. You file a suit. Go and file a
The
suit.
only issue is, I have told the Waqf.
Which matter?
Lord, this has to be filed.
Filed?
Get a number. Lord, I would, nowadays I'm telling, please don't brief me in the matters where I have to impress upon an urgency. But this requires urgency. I would not have mentioned otherwise.
When the notice was issued?
My lord, notice is issued, my lord. Tomorrow the 7 days comes to an end. I received it 4 days back. We drafted the writ petition, my lord, here before your lordship. 3rd of July is the notice.
3rd July,
Yes.
7 days, 10 July.
10, that's tomorrow. I'm before your lordship today, my lord. If I file it in regular course, I can provide the number today itself. If it can come tomorrow or on Monday, the lordship.
You are appearing for the Waqf board?
No.
No.
Lord, this indulgence kind. This is a original side matter. I won't
Issue
take
notice, issue notice.
I will certainly issue notice. Lord, the inscription has to be. Lord, if it is written, filed and moved tomorrow.
परसों क्या है?
Filed and moved
कल
tomorrow.
3 बजे क्या है? वही उन्हीं का है. सूट आर्गुमेंट कौन सा है? एविडेंस है. नहीं आर्गुमेंट है. आर्गुमेंट.
Issue notice. Filed and moved tomorrow, then it will come up.
Fine.
Urgent. I am deeply obliged. We are extremely.
Issue notice.
Yes, we'll do that.
Without notice, I will not hear.
I think notice can only be issued by giving the number.
Yes.
Get it.
Leave granted to file and issue notice. List tomorrow as urgent motion.
I'm deeply obliged.
Yes.
Item number 122. This is that matter, where SEBI has, frozen my accounts. Now, they had produced an order, we wanted to come back after taking instructions. The matter has gone down fairly. May any day convenient to the court, I'll not, by the clock, 5 minutes.
Who is for the others? SEBI?
SEBI, the learned advocate was appearing.
I think nobody has appeared on that.
No. She appeared. She was making submission. In fact, I was late. She had made submission regarding an appellate order. Of 20.
Yes.
That matter. Then there is a lot of things to say.
Lot of things.
Any day convenient to the court. Somewhere, fairly at the top. Any day, I leave it.
Any day कब होगा? 18 अगस्त, 20 अगस्त.
No, I'm taking a chance, my lord, if it can, my lord, anytime next week.
Within 10 matters, some.
Within 10 matters. Okay, Kalke. Very great. Grateful. Not a very bad news is there.
What?
Mr. Amitesh Banerjee's wife has expired.
Today?